So I would like to do that. Hello, everyone, and welcome to Uncivil Law. I hope you're having a fantastic day as always. And we are here with a React style video. Should be entertaining. So we are going to listen to oral arguments from the U.S. Supreme Court in two cases. Well, really three, because two of them were consolidated. But there are two oral arguments this week that we're going to listen to and react to, and I think it should be very educational and entertaining. And I hope you will agree. So both these cases deal with sexual-based discrimination in the workplace, or that's the allegation anyway. And so we're going to listen to it. And the two that we're starting with are dealing with discrimination on the basis of sexual orientation. And I thought we'd start with the questions as they are presented. So as I've often said, when discussing things with you guys, the question you ask is as important as anything else. And so I thought we'd see what actually is the question here. The question is whether discrimination against an employee because of sexual orientation constitutes prohibited employment discrimination because of sex within the meaning of Title VII of the Civil Rights Act. And similarly, the consolidated question, because there's two cases, the other question is whether the prohibition in Title VII of the Civil Rights Act against discrimination because of sex encompasses discrimination based on an individual's sexual orientation. So this case is dealing with sexual orientation-based discrimination. The law at issue states, and this is 42 U.S.C. section 2000E-2, subsection A1, says it shall be unlawful employment practice for an employer to fail or refuse to hire or to discharge any individual or to otherwise discriminate against any individual with respect to his compensation, terms, conditions, or privileges of employment because of such individual's race, color, religion, sex, or national origin. So we're trying to determine whether the acts that were encompassed here comprise sexual orientation discrimination. So a little bit about the cases. In Altitude Express versus Zarda, Donald Zarda was fired because he terminated because his employer found out that he was gay. And so that was the basis of him being fired. And he's arguing that that is prohibited because of sex discrimination under Title VII. And in a related case of Boonstock versus Georgia, Gerald Boonstock worked as a child welfare services coordinator in Clayton County, Georgia. Boonstock argued after the county learned that he was gay, it falsely accused him of mismanaging public money so that it could fire him, when in fact it was firing him because he was gay. So these are the two cases at issue, and we are going to listen to the consolidated oral argument, and we are going to react to it as we go along. So it should be pretty interesting. This occurred on Tuesday of this week, I believe, but the oral arguments audio doesn't come out till Friday. So the audio just came out today, and so we'll listen together and see what the justices had to say. So let's get started.
We'll hear argument first this morning in Case 17-16-18, Bostick versus Clayton County, and the consolidated case. Ms. Karlan.
Thank you, Mr. Chief Justice, and may it please the Court. When an employer fires a male employee for dating men but does not fire female employees who date men, he violates Title VII. The employer has, in the words of Section 703A, discriminated against the man because he treats that man worse than women who want to do the same thing. And that discrimination is because of sex, again in the words of Section 703A, because the adverse employment action is based on the male employee's failure to conform to a particular expectation about how men should behave, namely that men should be attracted only to women and not to men. There is no analytic difference between this kind of discrimination and forms of discrimination that have been already recognized by every court to have addressed them.
All right, so far she's off to a very good, promising start, in that the issue, as she's framing it, is because there is a discrimination because this man, is not acting the way that their employer thinks men should act. And so there's a discrimination here. Taryn Marine says the government employee was fired, the government's bloated. It isn't that the government employee was fired that's the problem. It's the reason the government employee was fired that is potentially the problem. The Civil Rights Act, it's Title VII of the Civil Rights Act, says in employment law, and applies to government agencies as well, says you cannot discriminate for employment on the basis of sex. So the question is whether or not this falls into the category of sex-based discrimination or not. And so far, she's off to a very good, promising start, and she is leading the charge very well. So very good.
For example, discrimination against men who are effeminate rather than macho. Like the discrimination here, that discrimination is because of nonconformity with an expectation about how men should behave. The attempt to carve out discrimination against men for being gay from Title VII cannot be administered with either consistency or integrity.
So there, when she's talking about consistency or integrity, she's trying to say that there's no way to segregate this as a rule. So if you want to say there's a rule that it's okay to discriminate on the basis of sexual orientation, then you need to create a rule, right? You need to create something that can be administered. You need to create a rule. And so she's saying, if you're trying to create this rule, you can't do it. It can't be administered consistently. It can't be administered in a way that is going to be cohesive or applied uniformly. You can't create a rule that says, if this is the rule, then you're within this category. And she says you can't do that. You can't separate sexual orientation from the sex-based discrimination. So the Title VII says you can't discriminate on the basis of sex. It doesn't say you can't discriminate on the basis of sexual orientation. But her point is that there's no way to really separate those two, that you can't discriminate on the basis of sexual orientation without also discriminating on the basis of sex. So she's basically saying they're one and the same thing. And for you to pull them apart and say sex is different than sexual orientation, there's no way to do it discreetly. There's no way to create two separate categories. So that's a really good argument so far.
In the words of the en banc Second Circuit, it forces judges to resort to lexical bean counting, where they count up the frequency of epithets such as fag, gay, queer, real man, and femme to determine whether or not discrimination is based on sex or sexual orientation.
I just want to note, how baller is it to be giving an oral argument at the U.S. Supreme Court and say the words fag, gay, queer, real man, and femme to the United States Supreme Court? I mean, that's pretty baller, I just gotta say.
Attempt is futile, because when a man is discriminated against for being gay, he is discriminated against for not conforming to an expectation about how men should behave. Finally, the possibility that some employers, but not the employers here, may have policies of denying employment opportunities both to gay men and to lesbians does not change the unlawfulness of what was alleged by the employees here. Labeling those policies under an umbrella phrase like sexual orientation discrimination cannot hide the fact that such an employer is a double discriminator. It discriminates against men who do not conform to a male stereotype, and it discriminates against women who do not conform to an expectation.
So let's just take note about how she's framing the argument. And for me, this is already 10 out of 10 argument, right? This is as much as that DA in the Amber Geiger case was as good as he was, this is on another level for me on how good it is, because it's just setting the stage so well. She knows the statute says you can't discriminate on the basis of sex. So if she says, well, there should be a rule that says you can't discriminate against sexual orientation, she loses. She can't make that argument. The statute says what the statute says. She has to make this work within the confines of her statute. So she says, look, this is discrimination on the basis of sex because it's discriminating against both men and women for not conforming to their type. So it's double discrimination. It discriminates against men and discriminates against women for not conforming to accepted or typical sexual behavior in terms of what you think they should do. So she's doing a really outstanding job in framing this.
Female.
Ms. Karlan, how do you answer the argument that back in 1964 this could not have been in Congress's mind because in many states male same-sex relations was a criminal offense. The American Psychiatric Association labeled homosexuality a mental illness.
Well, I think you read the words of the statute, and this Court has recognized again and again forms of sex discrimination that were not in Congress's contemplation in 1964. In 1964, those were the days of Mad Men. So the idea that sexual harassment would have been reached, most courts didn't find sexual harassment to be actionable until this Court did.
All right, so like here, this is a beautiful use of textualism to appeal to conservatives, and it's a beautiful use of precedent to also appeal to the court as a whole. So first of all, she says, you read the words of a statute. That's a textualist argument. That's straight down the line conservative legal thinking. It's like, we look at the text says this, that's a conservative legal argument. Then she comes here and she says, okay, we have precedent. Congress, if you're going to say Congress said a certain intent, they had a certain thing in mind in 1964 to go to an intent-based argument, which is not a typically conservative argument to go to intent. You say, but if you were to do it, this court has already said in prior cases that it doesn't extend in these other examples. So she's using precedent as a way to say this court has already interpreted intent of the text in a particular way. So she's making a conforming argument. So basically say this is in conformity with what the court has already done, not an aberration of what the court has already done. So it's a beautiful thing to go text, statute. That's a root, solid, conservative argument. And then you say it's lined with precedent. That's a broad appeal argument. Very good.
In Price Waterhouse, this court recognized that discrimination against a woman who cursed like a sailor, walked like a man, and didn't wear makeup was reachable under Title VII. If you had asked members of Congress then what they had thought, they would not have been thinking about women like Ann Hopkins.
Do you agree or disagree with Judge Posner's statement that the statute should be read to encompass sexual orientation discrimination, to, quote, avoid placing the entire burden of updating old statutes on the legislature?
All right. So first of all, Judge Posner is like, first of all, he recently retired. But second of all, he was probably, at the time of his retirement, in fact, not probably, he just flat out was. He flat out was the most notable judge other than a Supreme Court justice. He had been on the Seventh Circuit forever, and everyone looks at his opinions. So other than a member of the Supreme Court, he was the top judge in the country. All right? You'd be hard pressed to find anyone who disagrees. And so Judge Posner is saying, look, you need to do this because Congress won't do it. That is a distinctly not conservative argument. That would be the opposite of a conservative argument. That would be, we should do it because Congress can't get around to it. So he's saying, do you agree or disagree with Judge Posner's argument, which is the exact antithesis of a conservative argument? So she has to disagree with it because the court's conservative, and as you can see, she's about to. So let's listen to what she has to say.
Branch.
I disagree with Judge Posner. I don't think you need to do any updating here. I think you should read the words as they were understood then, which is men and women. Title VII was intended to make sure that men were not disadvantaged relative to women and women were not disadvantaged relative to men. And when you tell two employees who come in, both of whom tell you they married their partner Bill last weekend, when you fire the male employee who married Bill and you give the female employee who married Bill a couple of days off so she can celebrate the joyous event, that's discrimination because of sex. Well, if no one has any further questions, I'll reserve the remainder of my time for rebuttal.
Well, I don't know much about this woman, but I think it's hard for me to adequately express how big this woman's balls must be, because we are 4 minutes into this argument time. 4 minutes, okay? And she just said, in so many words, I've said everything there is to say. She just dropped the mic at 4 minutes in. She gets a half hour. She gets 30 minutes. And she just said at 4 minutes, yeah, I'm done. I'm done. I've said everything there is to say. 4 minutes. I don't know if I can adequately impress upon you how baller that is to do it. First of all, to recognize that you're actually done. I mean, I've been to the U.S. Supreme Court not as an arguer, but I've been there to observe. It's a bit intimidating, okay? First of all, to recognize that you're done. Second of all, to put aside your ego that you're done. And third of all, to be like, just to have to be like, oh yeah, I'm done. I don't have to keep making arguments. I don't have to keep I've said everything. And to be able to recognize that in the moment and be able to drop the mic at 4 minutes into a 30-minute speech, I don't know if I don't know how she gets up in the morning and walks around, because her balls of steel must be really inconveniencing her life, because it's hard for me to adequately express how ball that is. And it's like she just basically whipped it out and proved that hers is bigger than every other person in the courtroom. And the fact is that she's right too. She actually made her argument. She's actually right. And so it's like, to be able to do that, it's like I don't know what to say. It's like please let me work for you for free is all I can say.
Well, I think we'll have further questions. What do you do with the argument that this is a non-discriminatory policy because it applies equally to relationships between women and relationships between men? In other words, your friends on the or you emphasize that you need to know the sex of the individuals involved before you can determine whether or not there's a violation, and that brings it within Title VII. But what about the response that you do not need to know the sex of the people involved? You just have a policy against same sex. So you don't care whether the participants are women or men. If they're the same, then that's covered by the policy.
I think that's no different than having a policy that says everyone should comply with the stereotype applicable to their sex. And if I can use an example from the court's prior cases, for example, in Dothert against Rawlinson, the policy on its face said you cannot guard someone of the opposite sex. So a woman who seeks to guard a man is barred from that job. A man who seeks to guard a woman is barred from that job. Just put in, instead of the word guard, date, and you get the same kind of rule here, which is a man who wants to date a man can't do it, but a woman can, and a woman who wants to date a woman can't do it, but a man can. They are two forms of discrimination.
There's quite a difference. In Dothert case, it was the disparate impact. There are many more male prisoners to guard than females, so that policy, even though it applied to men guarding women, it had a disproportionate effect on women who wanted to be guards because there were many more jobs guarding male prisoners than female prisoners.
Justice Ginsburg, the part of Dothert against Rawlinson that rested on disparate impact was the height and weight requirements. The requirement about guarding the opposite sex was not a disparate.
All right, so I think it's really interesting. I would expect nothing less, but Justice Ginsburg just said, okay, this case seems to not rely on the same grounds you are. And she says, no, in fact, in that case, they relied on this aspect and not this aspect. So not only does she know the record of her own case cold, she knows the record of all the relevant cases cold, from memory. She's doing this from memory. So she just basically corrected a justice of the U.S. Supreme Court exceptionally professionally, and she said, oh, it was this and not this. She knows it cold. This is why the Supreme Court lawyers get paid the big bucks. Yeah.
Impact. At most, the court noted in a footnote along the way that there were more guard positions available to men, but it was not a disparate impact case. It was a disparate treatment case. And so a male person who had wanted to guard someone at the Julia Tutwiler prison, the prison for women in Alabama, would have had a claim that he had been discriminated against because of sex. Now, he would have lost that claim, but on BFOQ grounds, not on because of sex grounds.
BFOQ stands for Bona fide occupational qualification. If you want to put a lot of words in your mouth. So long story short, it is generally accepted that you can discriminate on the basis of sex in employment if the reason you're doing so is because of a bona fide, that means an actual real reason, not made up one, but a real reason, a bona fide occupational qualification. If there's some reason that it has to be a male and a female or vice versa, then it would be a bona fide occupational qualification. For example, at the TSA, which they do physical screenings of passengers, you can make a very credible argument that if a female passenger has to be searched by a person by hand, you would need to have a female person do that job rather than a male. So you would say, okay, for this purpose, if we're going to physically screen a female passenger, we want a female guard, not a male guard. Now you would say, well, that's discrimination. The rejoinder to that is it's a bona fide occupational qualification. It needs to be a woman because of reasons that you can come up with off the top of your head. So generally speaking, that's what a bona fide occupational qualification, if there's some legitimate reasons. And Joe Tysons, thank you as always for your continuing support. I very much appreciate it.
What do you do with the example that was brought up that, unlike race, there are certain distinctions that are not only permitted but maybe even required between males and females, like physical fitness tests?
So those, I want to answer that question in two parts. The first is to notice that in those cases, there is no question there's a differential between men and women. That is, men and women are being treated differently. What is at issue there is whether that differential treatment constitutes unlawful discrimination under Title VII. So, for example, in Johnson against Santa Clara County Transportation Agency, everyone recognized Paul Johnson was denied the job because of his sex, but because it was a permissible affirmative action program, that was okay. In Dothert against Rawlinson, this court said Miss Rawlinson is discriminated against because of sex, but there's a BFOQ. So if Congress writes an exemption into the statute, that's one thing, but this court really shouldn't be writing in an exemption for those purposes.
Yeah, so here she's basically saying that Congress, when they pass laws, can pass laws with exceptions to them. So in some cases, there might be a law that says, in this specific instance, for this specific reason, you can discriminate. Congress gets to write laws. So if they want to write a law and give a special exception to whatever, generally speaking, they get to do that. So, you know, that she's just basically saying, look, Congress gave an exception in this case. In the one case, because of affirmative action, there was an affirmative action program. Well, Congress wrote the law, so they can do that. They can discriminate on the basis of sex. They're the ones who created it in the first place. And as for this other thing, it's like, look, if you want some sort of exception, Congress can create it, but they didn't in this environment, so it's not applicable here. It's a fantastic answer.
I think we need exemptions for those BFOQs. It's not just the physical fitness standards for different sports, but the big issue right now raging the country is bathroom usage, same-sex bathroom usage. How are those cases going to be dealt with absent a congressional exemption other than BFOQ?
Well, I think the way that they get dealt with is everybody agrees if you have men's bathrooms and women's bathrooms, that's because of sex. It treats men one way, it says go to this bathroom. It treats women another way, it says go to this bathroom. Then the question becomes, is that permissible to do? And if I could just begin with an example that I think will show why this is so. When I got up, the Chief Justice said to me, Ms. Karlan, I am willing to bet any amount of money I have that when Mr. Harris gets up, he's going to say, Mr. Harris, he has treated us differently because of sex. But that's not discriminatory, because neither of us has been subjected to a disadvantage. And as this court said in Burlington Northern against White, what the statute means when it says discriminate against is to cause an injury. And requiring people generally to use separate bathrooms is not an injury.
Well, I'm not sure that may be how they would see it, and to what extent should we take that into account? And same thing with gender-specific uniform requirements. How would you deal with those, given that at least those affected might think that they're suffering a harm?
So there's no categorical rule about these. For example, the fact that all of the men sitting at council table knew that they had to wear ties today and I was free not to, didn't cause an injury. On the other hand, even the dissenters in the Second Circuit said if the court said women who come to argue should argue in Hooters outfits and the men should wear ties.
We're not. I mean,
I know.
We can talk absurd examples.
No,
we
but
can talk real-world examples.
I'll give you a real-world example, which is it probably doesn't violate the dress code to require men and women in business events for the women to wear skirts. But if you required a female telephone lineman to wear a skirt
I understand that. That's not what I'm getting at, and you know what I'm getting at. The funeral homes example is not a bad. The case that we're about to take up is more in the realm of my question.
Okay.
You could offer me help if you want to.
Yes. No,
right?
I'm trying to offer you help.
Right.
What I'm trying to
what I'm suggesting, counsel, is that there are male and female bathrooms. There are dress codes that are otherwise innocuous. Right? Most people would find them innocuous, but the affected communities will not, and they will find harm. And how does your test deal with that one way or the other? That's what I'm asking you to address, if you'd like to.
Yes.
Yeah, Lent says it sounds like the attorney actually took time to think about the possible questions. I wouldn't know for an absolute fact what they did, but I would strongly suspect, because I've done it to lesser degree. But when you're prepping for this kind of thing, you hold mock sessions. She's probably had mock Supreme Court arguments. There are people in businesses who specialize in this, like there are so many things. But you can get lawyers together and they pretend to be Supreme Court, and they ask questions, and you get different people and they ask different questions. You get different people and they ask different questions. And so basically it's like you trying your best to like prep for everything you can think of. And of course, she's had her own brief. She's had the opponent's brief. She had her response and all the amici. So she knows, she's been well informed as to the relevant cases. She's been told by lots of people what the relevant cases are. And so she's, I'm sure, read most of them, if not all of them. She's almost certainly read all the amici briefs in full. She's probably read many of the cases it refers to. She's had these prep arguments. So it takes a lot of time, a lot of prep, a lot of effort to get ready for a Supreme Court case. And that's why, going to the Supreme Court costs you like, $300,000, because it takes a lot of time and a lot of effort. So it's a lot of effort.
My test says that you have treated the people differently because of sex, which is what we are asking you to hold here. When you treat a gay man who wants to date a woman differently than a woman who wants to date a woman, that's discrimination. Then you get to what I've said, which is you have to ask whether a reasonable person under these circumstances would be injured by the imposition of the particular sex-specific rule. So when the Chief Justice calls me Ms., I am not injured. When I go to
You are not, but another person might be.
Right. And
are they reasonable or not? And I'm wondering, how do you decide those cases?
An idiosyncratic preference does not void an otherwise valid dress code or bathroom rule.
So I like that line quite a lot, in an idiosyncratic preference, because this is the thing that the court is worried about and the conservatives are worried about. The conservative legal thinkers, among many other things, like line drawing. They like categorization. They like things that put yourself into well-understood boxes. They like boxes. I say this as a conservative legal thinker. We like boxes. We like things that are understandable, and we can say, this is a rule, this is a rule, this is a rule, this is a rule. We all understand it. It's neatly arranged in our little organization, so we all know how to act and how to conform ourselves in law. And so she just gave a very conservative legal answer to a very conservative justice. She said, an idiosyncratic preference does not void an otherwise valid rule. She's basically saying, look, people gonna people. Some people are going to be extreme. We can ignore them. Those are not our people. We're not worried about them. Those are some other people. We can just ignore those people at the outer fringes. We're not talking about those. And, that's an outstanding answer. It's like we can cut off a line, and so we can put this in a box we can all understand. Excellent.
So I'm sorry. I apologize. Is it idiosyncratic for a transgender person to prefer a bathroom that's different than the one of their biological sex? Is it idiosyncratic for a transsexual person to wish to dress in a different style of dress than his or her biological sex? Okay. So the answer to your question is that the question then, at the end of the day, if I understand it, is that those are acts of discrimination under Title VII as you understand it.
Yes, although I think you'd be better advised to ask the question to someone who is representing someone who is transgender. I'm representing someone who's gay.
And so she's deflecting a little bit there, because the question he asked was about transgender issues, and that's the case in the afternoon. That's not her case. And so she deflected. It's a very fair deflection. She's like, I'm not dealing with transgender stuff. I'm just dealing with people who are gay. It's a deflection, but perfectly valid one. No problem.
Ms. Karlan, But you're begging Justice Gorsuch's question. We were following up on the same.
I truly am not trying to beg the
is,
question.
No, how do we differentiate the two? What is the legal test that you propose to say this is discrimination because of sex, as you said, calling you one thing and your friend another is discriminatory, but it's okay because there's no harm. So what's the test we apply to say when it is harm and when it isn't?
That was Justice Sotomayor who was speaking. That's why we have the little banner so you can see when they highlight the picture to see who is speaking. That was Justice Sotomayor, and it was actually a very conservative question. That's a question a conservative would ask. She's asking, how do we draw lines? That's a conservative question. So let's see what her answer is on how to draw lines. And obviously the attorney doesn't get a highlighted picture because she's not one of the justices. So if no one's highlighted, it's the attorney. If someone's highlighted, it's the judge who's speaking.
Let me try to be clear. It's not discrimination to call me Ms. Karlan and to call Mr. Harris Mr. Harris. It is because of sex that we were treated differently. But as this Court has made it clear several times, discrimination consists in an injury that the law is prepared to recognize. And generally, across all statutes, this isn't about Title VII, and this is why I'm really not begging the question here. The Court has said de minimis effects are exempted from statutes presumptively. So if this Court thinks, or if another Court
So why is a dress code for Hooters that requires all women to wear a scant dress, is that discriminatory?
Yes, it is.
Is it discriminatory for the woman who just doesn't want to wear it because it's demeaning?
Yes, it is.
So how about, is it discriminatory for the restaurant not to hire a transgender man who wants to wear the uniform?
Well, you're going to
I
mean, I do want to get to the question of sexual orientation
No,
here,
but I
understand.
what you're alluding is, and I still haven't heard the explanation, which is the question of how do we tell what's actionable and not?
Well,
when does that discrimination become
I'll give an analogy from the race area that may be helpful to the Court, which is for many years there was an argument that separate but equal was acceptable. And ultimately this Court concluded that when it came to race, separate but equal was not permissible. I don't think the Court has held anything like that with regard to sex. But you're going to have to answer that question about dress codes regardless of how you rule in either my case or in Ms. Stevens' case.
Can I say the test is
So she just basically answered by saying your question is irrelevant because no matter how you rule in my case, the issue that you just raised is going to be raised. So, like, is Hooters discriminating or unlawfully so for making their waitresses wear a particular uniform? It's like, well, no matter how you answer my question, that's a question that you have to answer anyway. So nothing turns on the answer to the question we're trying to answer. So it's a deflection, but again, it's a fair one. It's not material to the case. It doesn't depend either way. And no, I don't think Hooters sponsored this, but, you know, hey, I guess whatever.
Is the person injured? Yes, it's a differential based on gender, but most people are not injured by having separate bathrooms. In fact, most people would prefer it. So are you saying that we have to wait for the testing case for the person who might be injured by not being allowed to use the bathroom of the other sex?
I think it highly unlikely you're going to see cases like that. The bathroom issue has been around since the beginning of Title VII. Title VII has a special provision in 703A2 that says when you segregate people, the question is whether that segregation denies them employment opportunities. And it's hard to see, quite honestly, how requiring men to use a men's room and women to use a women's room denies them employment opportunities.
May I ask you to, Justice Alito? May I ask?
Someone said the court has to wait for a case to show up. Yes, the court has to wait for a case to come up. The court does cases or controversies under Article 3 of our Constitution. The jurisdiction of the court is to actual cases or controversies, so they have to wait until a case comes up. So they can't answer questions other than the ones that are being asked. So, yep, that's 100% true.
You to respond to what some people will say about this court if we rule in your favor. And what they will say is that whether Title VII should prohibit discrimination on the basis of sexual orientation is a big policy issue, and it is a different policy issue from the one that Congress thought it was addressing in 1964. And Congress has been asked repeatedly in the years since 1964 to address this question. The Equality Act is before Congress right now. Congress has declined or failed to act on these requests, and if the court takes this up and interprets this 1964 statute to prohibit discrimination based on sexual orientation, we will be acting exactly like a legislature. We might as well just take the Equality Act and issue that as our opinion and say, as Judge Posner said, that the courts need to intervene on questions like this when the legislative branch simply will not do so. How would we respond to that question?
So first, let's discuss what Justice Alito is saying. So first of all, he's saying a couple things. First of all, he's saying, like, the question of how should we treat people with regards to sexual orientation is ultimately a policy-based question, and I don't think we would disagree with that. To the degree to which it's already been codified in law or not is a legal question, but the ultimate question is a policy-based question, a political question, if you like. What should we do? The normative question, what should our policy be, is a policy-based question, a political question, not necessarily a legal one. And he's also pointing out that, Congress has been asked multiple times, and there's legislation pending right now in the Equality Act for Congress to explicitly do this. And Congress has so far declined to do it. Now, that may indicate something. It may indicate that Congress is, by its own actions, indicates it doesn't think that it's in the law now and thinks it should be. So that may be indicative of something. And the fact that Congress has failed to do this, maybe that should be indicative of something, either as to how we're interpreting the law, as to what it meant or what sex meant in 1964 when this thing was passed, or how we're interpreting it now, all that kind of stuff. So, yeah, that's a little good stuff. Cody Sam says, couldn't they technically call any particular thing a controversy, though? So Article 3 of the Constitution says a case or controversy, and so it has to be, first of all, it has to be something that's recognized at law. These are courts of law. It has to be a case or controversy within the meaning of law. There has to be a legal controversy, something the law recognizes as a controversy. There has to be a dispute between two people as to the law. And so, and also the Supreme Court is a court of appeals. They have original jurisdiction in very few cases and none that are relevant here. So it has to go to a trial court first, and then it gets appealed. And so, and there's all kinds of guidelines as to what kind of cases they do and do not hear. So, the Supreme Court is a very institutionally conservative group. Regardless of liberal conservative philosophy, it's institutionally conservative in that it does things in a particular way in terms of rules and process. It's very process oriented. And so they can't just do anything they want at any time they want. There are ways in terms of how they hear things. So those are answer to your question, hopefully, and also what Justice Alito is talking about here.
Well, the fact that a loose cannon like Judge Posner says, do whatever you feel like, is not what we're asking for.
I paused to take note that she described Judge Posner as a loose cannon, which, it's a little hurtful, but whatever, carrying on.
Saying if you read the words, because of sex, and you ask in 1964, what did those words mean? They meant treating men differently from women. So if in 1964 it would be discrimination to fire a woman who wanted to, a woman who enjoyed sewing, and there's a famous case, it's the foundational case on sexual orientation where they fired a man who said his body was
We would not be deciding a major policy question that was not in Congress's mind in 1964 and that Congress has repeatedly failed to address in the years since then.
No more than what you did in Uncal, no more than what you did in Price Waterhouse, no more than what you did in Newport.
But is there in my mind, there are three basic parts to this case on the other side.
So that was a pretty good answer for her, too. He's basically said, aren't we treasuring into a policy answer? He's like, well, no more than you did in these other cases. And those other cases are conservative landmarks. So she's basically saying, Oh, you've already done this in areas that you care about, so what's the difference? Nice little, it's a very professional way of calling out the Supreme Court. In case you wanted to know how you professionally call out the Supreme Court, when she said, not as you did in Price Waterhouse, that's how you professionally call out the Supreme Court. It was so professional, you didn't even notice it happened. But I did, because that's how subtle it is, but it's really, really good.
The language, you've dealt with that. The parade of horribles, you've dealt with that. And the third one is the one that Alito is bringing up in one form. As it comes out of the briefs, as I read it in your opponent's brief, I would put it in these terms. Imagine a statute that says policemen, must pay damages. Passed a long time ago. That doesn't apply to German policemen.
Doesn't apply to what?
To German policemen. The meaning is the same. German policemen are policemen. But the statute doesn't apply to them. How do we know? Well, we know through a lot of history, Okay? Now, that's the box in which I put the argument that Justice Alito made. It's a serious legal argument, and the argument is that at the time, Congress wouldn't have dreamt of this. And therefore, the words, though they apply, they meant to exclude the gays and transgender. Now, what I need to hear is a clear answer to that question.
So this hypothetical that Justice Breyer elucidated was not the best written hypothetical I've ever written, but that's okay. They can't all be gems, right? So he's basically saying, suppose there is a statute that on its text says policemen shall do X, but at the time it was understood that it did not apply to policemen who are of German descent. Why? I don't know. This is a hypothetical. It's not that well created. But let's just suppose that Congress passed a law that says policemen shall do X, and at the time, policemen was not understood as including German policemen. But the statute says policemen, unqualified. But everyone knew it didn't include German policemen. That's the hypothetical. So it's like, when we read policemen today, should we read it on its plain text or read it based on the understanding? So with that hypothetical in place, he's like, okay, look, the statute says sex, but at the time, no one thought it meant this. And so on its plain text, it means one thing. But if we view it based on history, which typically is a more liberal argument, to be fair, if we view it based on history, then we wouldn't read it in. So that's the hypothetical. It's a little muddled, but what can you do? It's what he came up with.
I think the way to think about this is to ask about the specific behavior that's at issue, which is a man dates a man, and then ask, how does that fit within the language? And the best example I can give...
It fits.
I'm about to explain why it fits, which is the idea was that people should not be denied jobs that they're qualified to do. Award-winning advocates for child services like Gerald Bostock should not be denied a job because they are a man who does something that, if they were a woman, would cause no problems at all. So just to give an example from the first sex discrimination case this court had, which was the Phillips against Martin Marietta case, a woman who has children at home should not be denied a job that a man who has children at home. Now, all you have to do is say those words apply also if it is a woman who has a wife at home rather than children.
Several, I think about 23 states have been passing laws to address these issues. And I don't know how many of them, but I think it's a big part of them. When they do extend the coverage against discrimination on the basis of sex to sexual orientation, transgender, they also include an exemption for religious organizations. Now, if we're going to be extending the understanding of what sex encompasses, and I know your argument that that's not doing that, how do we address that other concern that at least I think almost every state legislature that has extended it has felt compelled to address?
Well, I would say three things about that. The first is this court has already created an exemption for sincere religious belief for a large category of employers through the ministerial exception. The second is that Congress balanced these issues and has rebalanced them several times in the co-religionist exception. The third thing I would say is to understand this in context, which is 85% of American employers are not covered by Title VII at all. So as to those employers, if they have religious objections to hiring someone who's gay, they're free to continue doing that. And the fourth is to make it very clear that the question is not whether people have religious objections to homosexuality. It's whether they have religious objections to hiring someone who is gay or lesbian. And there are many employers whose own religious beliefs would tell them this would be immoral for them, who have no problem hiring gays and lesbians who are qualified to do a job. If I could just ask the Court to do one thing in thinking back to 1964, it is to look at the two foundational opinions on which everybody has played a game of telephone ever since. It's like your opinion last term in Argus Media, where you asked, where did the idea that homosexuality wasn't covered come from? It came from, first, a case where a gay black man said he was being treated worse than gay white men. It wasn't even a sexual discrimination case. The second one came from a straight man who was fired who was denied a job because he said his hobby was sewing. And the employer said, that's an effeminate hobby, so I bet you're gay. If you look at the reasoning in those cases, you will realize that it was not until Hively that any court did a careful reading of the statute using contemporaneous methods of textual interpretation.
To my friends in the chat who are still trying to address the hypothetical, first, they have a famous saying in a court to lawyers. So just FYI, first they say to lawyers, don't ever attack the hypothetical. It's bad form. The judge came up with the hypothetical. Even if it's horrible and the judge knows it's horrible, you don't gain anything by calling out the judge. So first thing is you have to deal with the hypothetical. Second of all, the hypothetical is horrible, okay? It's just a bad hypothetical. Don't read too much into it. It's not a good hypo. I don't know what they meant. It's a bad hypothetical. Let's just move. Let's just give the most charitable interpretation you can in your own mind and just pretend that he said that, okay? Because the hypo was not very good. Hey, they can't always be brilliant, guys.
And since then, a majority of judges have held that sexual orientation is a subset of sex discrimination.
Justice Breyer characterized what I said earlier as conceding that sexual orientation discrimination fits the words of Title VII, but that we should take a broader view of what Congress had in mind. But that was not the premise of my argument. I mean, your core. The parties have, in their briefs, have all of these comparisons, and they will make your head spin if you try to figure them all out. But let me just go to your core one, which you began with today. A man is attracted to other men, he's fired, let's say. A woman is attracted to men, she is not fired. You say that's all you need to look at. That's discrimination on the basis of sex, right?
Yes.
Okay. That's not correct, because there are two possible explanations for what happened there. It could be based on sexual orientation, or it could just be based on the fact that the employer does not want to hire men. Now, if you add in two other cases, a man who is attracted to women, not fired, a woman who's attracted to women is fired, then you have a much better idea of the basis for the discrimination, and it's sexual orientation, it's not sex.
So this hypothetical is, let's suppose you fire a man because he's married to a man. The question is, did you fire him because of sexual orientation, or did you fire him because of sex? Did you fire him because he's gay, or did you fire him because he's a man? So it's an attempt to differentiate the two. He's saying, look, you don't know from the fact that you fired this man because he's married to a man. You don't know from that pure fact alone if it was on the basis of sex or sexual orientation. And to the extent there's a difference, that would be important. That's at least what he's trying to reach at.
But in a case like the two cases before this court where the employer had hired these men and they were already there, the supposition you made in your question doesn't apply, which is we know this is an employer who's willing to hire men. Indeed, the employer in Don Zarda's case had only men as skydiving instructors. So when he fires a man who wants to date a woman, a man who wants to date a man, and he does not fire a woman who wants to date a man.
The point is that
Well, Cody says, careful trying to divide orientation and sex, which tells us he's got a deep understanding of the differences, so he's just being obtuse, not ignorant. Well, I would counter here that it's not necessarily being obtuse. It's an issue of line drawing. It's like, to the extent that you think there's a difference between sex and sex orientation, it's not being obtuse to ask what the distinction is and saying, look, if you're firing this guy, you don't know which category it's in, and it could be either one. So I don't know if it's being obtuse as much as it is line drawing. It's like, it's what is the distinctions? We're going for these like ideas, so it requires exploration and bumbling around a little, but I don't find it particularly obtuse.
Discrimination on the basis of sex, in the sense that Congress understood it in 1964, is a different concept from discrimination on the basis of sexual orientation. And that's what you're fighting. You're trying to change the meaning of what Congress understood sex to mean and what everybody understood sex to mean.
I'm not trying to change that at all. I'm simply saying that if a man and a woman both wanted to sew, and you fire the man who loves sewing and you don't fire the woman who loves sewing, that's discrimination, pure and simple sex discrimination. If you fire the man who Thank you.
Thank you, counsel. Counsel? Sorry.
For those of you who might have missed why that was funny, you might remember earlier the thing she said when you brought me to this podium. The Chief Justice introduced me as Mrs. So-and-so, and I'd bet any amount of money that when he calls my opposing counsel, he's going to say Mr. So-and-so. So the reason it's funny is because the Chief Justice didn't refer to him as Mr. He just called him counsel. So that's the joke.
Mr. Chief Justice, and may it please the court.
Touche.
In 1982, Wisconsin became the first state in the country to pass a law banning discrimination because of sexual orientation in private employment. The proponents of that law celebrated its passage as a landmark achievement for gay rights. According to the plaintiffs here, however, Wisconsin's landmark law actually had little, if any, practical impact because Congress had already banned sexual orientation discrimination nationwide 18 years earlier in the Civil Rights Act of 1964. To quote Judge Lynch's dissent below, Congress did no such thing.
Okay, so that's a pretty good point, right? So we just said, like, look, Wisconsin had this law and they banned sexual orientation and everyone was super, super happy when that happened. But in fact, Wisconsin had no reason to be happy because they had already done that. So it's a really good argument. That's a nice way to start.
Sex and sexual orientation are independent and distinct characteristics, and sexual orientation discrimination by itself does not constitute discrimination because of sex under Title VII. That's just as true today as it was in 1964. The core error in the Second Circuit's holding is actually quite similar to the error that led this court to reverse in Oncal. In Oncal, the Fifth Circuit had held that same-sex harassment claims were categorically excluded from Title VII. This court correctly reversed and held that such claims may well be cognizable as long as the plaintiff meets all requirements of the statute, especially what this court called the, quote, critical inquiry into whether members of one sex were being treated worse than members of the other sex. This case is just the mirror image of Oncal.
So that's a pretty good argument, right? So he says the right issue is inquiry into whether members of one sex are being treated worse than the other sex. So sexual discrimination, the issue is a sex being treated differently than another sex? And so his argument basically is like, look, as long as you're firing both men and women for dating people of the same sex, both men and women are being discriminated against equally, and so therefore it's not being treated worse. It's not a bad line of argument.
Whereas the lower courts in Oncal adopted a categorical exclusion, the Second Circuit adopted a rule of per se inclusion in which plaintiffs alleging sexual orientation discrimination receive a free pass around the critical inquiry into whether men and women are being treated differently because of their sex. In short, the Second Circuit simply changed the ultimate question from sex to sexual orientation. But because both men and women may have same-sex attractions or partners, a standalone allegation of sexual orientation discrimination cannot, without more, show discriminatory treatment.
Can I understand your argument in context? Let's answer the question. Employer looks at a man who applies and says, one of my hobbies is sewing. And the employer says, that's an effeminate hobby. You may be gay. I'm not hiring you. So is that a mixed motive case? And are we going to be trying somehow to parse that there's some sort of substantial legal difference between the belief that you're too effeminate or that a lesbian is too macho, whichever, from you're attracted to the other sex? How do you tease that out?
Justice Sotomayor, I don't disagree that there will be tough cases at the margins, but the problem with what the Second Circuit did is they glossed over.
Not a great answer. She just basically said, what's the line drawing? How do you separate these two things? And he said, they're tough cases in the margins. It's a bad deflection. Bad answer.
Those hard questions and said, we're just going to adopt a per se rule that if you
aren't you glossing over the BFOQ? Meaning, what it seems like you're confusing is three concepts. Title VII has causation and injury. Not hiring, not firing, that's the injury. Now the question is, what caused that? Being too effeminate, that's a sexual trait. Being attracted to, if you're a man, to another man, that's a sexual trait. It's caused by those two things. Aren't then we moving to the third question, which is there a reason independent of your religious belief or your innate hatred and invidious discrimination for why you're treating this person differently? And if there is, you have a BFOQ. You don't have to hire them. You can fire them. But if there isn't, and they're doing their job, and they're not bothering you, and they're not bringing their boyfriend or girlfriend, if it's the opposite sex, to a function to your private home because you don't want them there, or whatever else is offensive to you, they're just working. So I don't understand why those are hard cases.
Mr. Lent asked, what is BFOQ? BFOQ stands for Bona fide occupational qualification. Basically, if you're discriminating on the basis of sex, there's some legitimate reason that you're discriminating on the basis of sex, some reason why it has to be one sex versus the other because of the particular job function. That's BFOQ.
Any harder than what the law applies for race discrimination, for religious discrimination, for any of the other forms, national origin discrimination?
So, Your Honor, as this Court has emphasized in cases such as Johnson Controls, the BFOQ exception has been interpreted extremely narrowly, and so I think it is important, as this Court emphasized in OnCal, the Court emphasized several times the need to ensure strict compliance with all requirements of the statute, including the discrimination element, because once you find discrimination, it gets very hard to make out the BFOQ. So
Would OnCal have come out differently if the employer said, I don't hire women to work on platforms, the only people I hire are men?
Well, that obviously would have been discriminatory against the women seeking.
But it's not the woman who's suing. Right. It's the male who is being harassed by other men. And the employer's defense is you can't compare what I'm doing to someone who discriminates on the basis of sex between men and women, because I don't hire women at all.
So it's, of course, it's not a complete defense or even a defense to say I treat it. In cases like Martin Marietta, it was not a defense for that employer to say because I hired other women, it excuses this. So the answer to your question is that would not be a defense.
That was Martin Marietta was different because it was the plus. The plus applied to women and didn't apply to men. So you had that distinction. Well, take Price Waterhouse. Suppose the employer said, I don't want any men who are not sufficiently macho, and I don't want any women who are not sufficiently feminine. If the Price Waterhouse said, we'll treat a man who isn't sufficiently macho the same way we treated Ann Hopkins, there would be, as I understand your argument, no sex discrimination.
I disagree with that, Justice Ginsburg. I think the best way to think of Price Waterhouse is when an employer has certain traits or characteristics that it values in promotion, in hiring, in discharge decisions, there can't be a list of criteria for men and a list of criteria for women. So the Solicitor General offered the hypothetical that Your Honor said, and in that situation, there would be two sets of criteria. And so maybe both a man who doesn't meet the women's criteria and a woman who doesn't meet the men's criteria would have a claim there. But it would not excuse it just to say that there are different criteria for each sex.
Suppose Catholic, Jew, want to get married. Employer fires the Catholic. Why? He's not against Catholics. He's against intermarriage. And obviously I can use the same example with race, which is famous. I take it from your argument that there would be no claim.
There would, in fact, be a claim in both situations.
Why? All right. If there is a claim there, why isn't there here?
So in the race context, the only difference between...
I didn't say race. I said religion.
In the context of religion, which, first of all, religion is defined as is the only one other than pregnancy which has an expansive definition.
Cody Sam says, how would that be defensible now with fair labor standards? It should come out the same because fair labor still deals with bona fide occupational qualification. So the standards are the same as I understand them. So you can discriminate on the basis of sex and fair labor for the same reasons. This is a bona fide occupational qualification. And as the court as he pointed out in argument, and as is correct, BFOQ is fairly narrow for very obvious reasons. So it has to be pretty specific. You know, the female guard to physically search a female suspect would be on point. That's the kind of thing they're talking about.
Yes, it would be religious discrimination because between a couple that is Catholic and Jewish and two Catholics, the only difference between those couples is their religion.
And the only difference between the two couples here is that one is a man rather than the woman.
Except it also introduces an independent characteristic which can be completely neutral.
So does it there. I am not against Catholics. I am not against Jews. I am against intermarriage.
If that person or actor exists, I think it's foreign to our case law.
I promise you, there are many people, at least in the religious context, who are against intermarriage and are not against Catholics or Jews. That's not an unrealistic example. And all I find in that example is an identical case to this one.
And I do think that most people who would oppose any sort of interreligious marriage would do so for religious reasons. And I would also note in
Mr. House, I think what all of these hypotheticals are about is that in many of our cases, what you find is what you said. What did you say? Independent characteristics. They're all over our cases. If you take Manhart, which is the seminal case, Manhart was all about an independent characteristic. It was about life expectancy. But we didn't say, oh, we're going into some different sort of analysis where we don't just say, would the same thing have happened to you if you were a man, or would the same thing have happened to you if you were a woman, because we had an independent characteristic, which was life expectancy.
So a couple questions. Someone said shades of Milo. I mean, you could make an argument, and I think there's an argument to be made that, you know, people who are really extreme, like Milo, take arguments that are not extreme and blow them to the extreme. So, you know, there's arguments that Milo is making that are reflective here, but doesn't necessarily mean that those are improper or invalid arguments. To the extent they're conservative, they're valid conservative, and to the extent they're liberal, they're valid liberal. You know, just because Milo takes an extreme position doesn't mean the less extreme position is invalid. You know, it's obviously there's just the same problem with sovereign citizens. They take everything well past 11 to, like, I don't know, 25 or something. But that's basically a problem. And Mr. Harris, I wouldn't say he's getting his head handed to him, but he's not doing as well as his counterpart. His counterpart had a much easier time and a much better, more cohesive answer, and he's having to tap dance around a lot more. So he's not getting his head handed to him, but it's not going as well for him as it was for his counterpart.
So the same thing here. So all of these hypotheticals are really about the same thing, which is that Manhart gave us a very simple test. And Manhart said, what you do when you look to see whether there is discrimination under Title VII is you say, would the same thing have happened to you if you were of a different sex? And Ms. Karlan made all the, went through all the ways in which, obviously, the same thing would not have happened to you if you were a different sex, you being her client. So, that's the question. There are independent characteristics in all these cases. We have insisted on this extremely simple test. If you apply that test, I guess it seems to come out against you.
A couple things. First, let me address Manhart and then address the test more generally. So in Manhart, this court noted that the policy wasn't just about longevity. That employer made no attempt to do any sort of bona fide underwriting or life expectancy estimates. It simply charged the women more. So even a woman and a man, if they each had a 75-year life expectancy, they would be charged different rates, even though they were totally similarly situated with respect to that.
Yes, but Manhart was very clear that women in the aggregate were probably going to be fine under this policy, because women in the aggregate do have a higher life expectancy. I think actually Manhart makes clear why another aspect of your argument is wrong, because you say, well, we have to look at these big classes. Well, there was nothing wrong in Manhart when you looked at big classes. What became wrong in Manhart was when you looked at individuals. And when you look at individuals, which Manhart insisted one should do, and when you apply the test that Manhart insisted you apply, would this woman have been treated differently if she were a man? The answer was yes. And similarly, I guess I'm just going to ask you again, if you applied that test, don't you lose? And if you do lose, why should we not apply that test?
Here's the problem with the test. In Manhart, in Newport News, in Martin Marietta, the comparator test makes perfect sense because you know exactly what you're testing for, so the comparator helps you draw inferences from the evidence. The problem here is, unless the plaintiffs can point to something outside the comparator to tell us why we need to hold sexual orientation, to tell us why that's irrelevant, they're just assuming their conclusion. So their comparator would say, you would ask if a gay man has suffered sex discrimination by comparing him to a heterosexual woman, which that version of the comparator can't isolate if it's the sex or the sexual orientation. And so I do think, unless they can point to something outside the comparator to justify putting...
So his point there is an interesting point. So he's saying, look, if you fire a man because he's married to a man, the contra example, right, is the woman who's married to a man. You didn't fire the woman because she was married to a man, even though you fired the man because he's fired the man. But the question is, when you make that comparison, there are two things that are different. One is the sex of the woman, and the other is the sexual orientation of the woman, right? The woman is different because she's a woman, not a man. She's also different because she's straight and not gay. So therefore, you can't tell if you fired the guy because of sex or sexual orientation, because there's two things that are different, not just one thing that's different. It's not a horrible line of argument. It's probably not going to win, but it's not a horrible line of argument. So let's continue to see what he says.
Sexual orientation off limits. The comparator doesn't answer the ultimate question.
Well, it certainly may not isolate the sole or proximate cause. But I think the argument on the other side is the language of the statute has a but-for causation standard, a more generous causation standard. So perhaps there are two causal factors at work here, but isn't one of them sex in the narrow sense of biological gender? What's your response to that?
Yes, so in the what I'm arguing is simply that sexual orientation standing alone is not, without more, sex discrimination. And so I'm sorry, remind me of the question one more time.
Sure. So your response to Justice Kagan was, I need to focus on sexual orientation because that's the sole or primary causal factor here for the firing. And I think the response from the other side is, but the statute has a more generous causal formulation, a but-for causal formulation. So perhaps you're right that at some level sexual orientation is surely in play here. But isn't sex also in play here because of the change of the first variable?
Right. So I think...
And isn't that enough? The statute talks about a material causal factor or some formulation like that, not the sole cause, not the proximate cause, but a cause. And one would, in what linguistic formulation would one say that sex, biological gender, has nothing to do with what happened in this case?
Yes, Your Honor. So what you're referring to, I believe, is the motivating factor language. And so in what I just referred to as the sort of benchmark scenario, sex would not be a motivating factor there. If you look at Mr. Bostock's complaint, for example, and you strip out any mention of his sex as being a man, again, we dispute the allegations, of course, but it would still make perfect sense. But if you stripped out any reference to his sexual orientation, it would make little, if any, sense. And so in Price Waterhouse, this court helped give guidance about how to do the motivating factor analysis and said, imagine you gave the employer truth serum and said, what were your true reasons for doing this? Would one of them be the characteristic? And what I would call that benchmark scenario,
all right,
sex would not be.
Let's do truth serum, okay? Wouldn't the employer maybe say it's because this person was a man who liked other men? And isn't that first part sex?
Your Honor, I think in common parlance, we would call that a same-sex attraction. And I want to be clear, if there is some reason to think that employer, and some of the amicus briefs say that much discrimination against gay and lesbian people is based on sort of animus against gay men or lesbian women. If there's some reason to believe that in that scenario, then that may well be a motivating factor. But when you simply have an employee saying, I was fired because of my sexual orientation, that alone does not show that what this court called in Oncal, the critical issue of distinguishing between men and women.
Are you drawing a distinction between the literal meaning of because of sex and the ordinary meaning of because of sex? And if so, how are we supposed to think about ordinary meaning in this case?
I don't see a difference between the two as far as And the last point, running out of time, I think to go back to some of the questions about bathrooms and fitness standards, I want to be clear. Under the plaintiff's simple but-for test, if you truly simply apply the Manhart test or in the way they want to do it, I don't see any way that single-sex bathrooms or showering facilities...
You have to have someone who's injured. You have to have someone who's injured, and the response to the bathrooms is, who is the complaining plaintiff? And for most people, they would not be complaining plaintiff. They would not be eligible because they're not injured by the separate bathrooms. In fact, they like it.
Yes, Your Honor. Although, of course, if someone, for example, is fired, imagine a factory with hazardous materials where people shower after work and to clean up, and a man used the women's bathroom and is fired, that person would certainly be injured. And I think under my friend's test, they would say, just change the sex, and that person wouldn't have been fired. But here's the problem. That's not a similarly situated person. The proper analysis would say that a neutral policy, such as use the showering facility that corresponds to your biological sex, the man who uses the women's shower, the comparator is not a woman who uses the woman's shower. It's a woman who uses the men's shower, because otherwise you're loading the dice, or you're not looking at similarly situated people. And the last thing I'd like to get into is this court in Espinoza, footnote 2, I think there was some discussion of the states early on. In Espinoza, in interpreting national origin discrimination, this court said that the state practice interpreting parallel laws is highly instructive. And so I think the fact that 22 or 23 states have done this by legislation and 0 have done it by judicial interpretation just shows that this isn't belt and suspenders. It's not just redundancy, that sex and sexual orientation, both in 1964 and today, are different concepts that mean different things, and common users of language, both today and in 1964, would have recognized that.
So that's a really good original meaning argument, which does fall more in line with the conservative argument. So like when you look to a statute, any statute, it means what it meant at the time. And so you look to how a person in the time would have understood it. Now, that doesn't completely work because, as the person who went first, the woman, pointed out, a lot of these things have been extended beyond that, and perhaps that's a problem. But this is a reasonable line of argument from originalist conservative thinking. It's like, well, we look at how these languages was used when the thing was passed, and so it meant a particular thing. And, the states that have done this have done it all by legislation, and so you should follow suit. So that has some conservative appeal to it. Let's carry on.
Can they ever be?
I'm sorry.
Can they ever be? Justice Judge Lynch below said that homophobic stereotypes are unrelated to sexual orientation. The very first case before us shows that that's just not true, that homosexual orientation is highly correlated to people's stereotypes. If you're too effeminate a man, you're a homosexual. If you're too macho a woman, you're a lesbian. Happens all the time. So I find it somewhat difficult to unwind the two. If not difficult, nearly impossible.
It often is, Your Honor, and it's a sad reality that homophobic slurs are often directed at heterosexual or homosexual people
and
criticize.
That's okay under your theory.
It is absolutely not, Your Honor, if that person can show discrimination because of sex. But what the courts can't do is what the Second Circuit did and the Seventh Circuit did in Hively. Footnote 11 of the Zarda opinion is very candid about this, where it talks about operationalizing its holding. The Second Circuit is just going to change the jury instructions to tell juries that if they find sexual orientation discrimination, they've now found sex discrimination. So, Justice Sotomayor, I don't disagree that there will be difficult cases at the margins, but the answer is not to change the ultimate inquiry and replace it with something that Congress never could have intended.
Well, if you have a minute, let me ask you this. Let's imagine that the decision maker in a particular case is behind the veil of ignorance, and a subordinate who has reviewed the candidates for a position says, I'm going to tell you two things about this candidate. This is the very best candidate for the job, and this candidate is attracted to members of the same sex. And the employer says, okay, I'm not going to hire this person for that reason. Is that discrimination on the basis of sex, where the employer doesn't even know the sex of the individual involved?
May you please?
Just in case you're wondering, he asked, may I? Because his red light went on. So at the podium, there's a green, yellow, and red light. This is old school. And so the light went on, which means you have to stop talking. So he has to ask for permission to answer. And as you can see, it's going to be a very short answer because he's out of time, which is what you should do. So good practice for him. This is exactly what you should do.
That would not be discrimination on the basis of sex. And I think that's exactly right. If you get a resume that has a name that could be male or female, and there's something on there suggesting that the person is gay and they're not hired for that reason, that would be sexual orientation discrimination. That has absolutely nothing whatsoever to do with sex discrimination.
Thank you, counsel.
General Francisco would be Solicitor
General,
by the way. Solicitor General.
Mr. Chief Justice, and may it please the Court. The issue is not whether Congress can or should prohibit employment discrimination because of sexual orientation. The issue, rather, is whether it did so when it prohibited discrimination because of sex. It did not for two reasons. First, sex means whether you're male or female, not whether you're gay or straight. So if you treat all gay men and women exactly the same regardless of their sex, you're not discriminating against them because of their sex.
That's fair.
Second, any doubt is removed by the history of Title VII and related statutes, since in the face of a unanimous interpretation by the courts and the executive branch that persisted for decades, Congress has repeatedly extended other statutes to specifically cover sexual orientation, yet has refused to do so with respect to Title VII.
That's a good line of argument.
The employee's position would nullify that conscious choice. And Justice Gorsuch, if I could first address your question about my friend on the other side's argument about the literal meaning of the statute. Well, there are essentially two responses to that argument, and they're related. The first is that under that interpretation, you actually couldn't fire a man for using the woman's restroom, because in some metaphysical sense, that man's sex is a but-for cause for his firing.
So those really good lines of argument from the Solicitor General, basically saying a couple things. First of all, he's doing basically parallel construction. So what he basically said is like, look, over the years, Congress has amended all these other statutes to put sexual orientation in, but not this one. So he's arguing by parallelism, right? He's like, look at all these parallel things that are similar in similar contexts, where they've added sexual orientation to these other things, but not here. So it must be the case, because we assume that Congress is not passing laws redundantly, right? Congress is passing laws to say something new. And that changes of laws have an operative effect. In other words, if Congress is changing the law, we presume it must be to change the law, right? They're not going to change the law just for the hell of it. If they're changing the words, it must be changing the meaning in some sense. Otherwise, what's the point? We're going to presume that when Congress acts, it acts meaningfully. So Congress, all these other times, it has put sexual orientation in. It must be because it was a meaningful change all these other times. So you can't argue that it's here when it's not, because to do so would be to say all these other times Congress has added in this clause would be unmeaningful times. Congress acted unmeaningfully. And that doesn't make sense. Congress doesn't do that. So it must be the case that by parallel construction, all these other times it was meaningful. Therefore, its absence here is also meaningful. It's a pretty good line of argument. Good job so far.
But he's not injured. He's not injured.
Well, he's fired, Your Honor, in my hypothetical. And the reason why that is permitted is...
I think counsel acknowledged all of that.
Yeah, and the reason why that's permitted, though, to do that is because you're treating, and this is my second point, you're treating him the same as a similarly situated woman. That is a woman who uses the men's room. And that's always...
Evan Marshall said, how many times has Congress passed something meaningless? Well, I suppose it depends what you mean by meaningless. Do you mean meaningless legally or meaningless more in a practical sense? Because if you say there's a lot of things that Congress does that have limited or de minimis even practical value, then that could be one thing. But to say that they don't pass, when they pass a law, it's meaningless. I don't know if you can point to anything that Congress ever did where they thought that's a law, not a resolution. You know, obviously resolutions are just states of intent, but we're talking about a law, a bill. You know, I don't know if you can ever point to a bill that Congress passed that was legally meaningless, had no legal impact, even if it was very minimal practical impact. So that's what I would say. It's that, you know, it may have ultimately been unconstitutional, so it may have ultimately been legally void, but they thought it was legally meaningful when they passed it. Congress doesn't do things that are legally meaningless, you know, even if they're practically, or they're symbolic. So, yeah.
The critical analysis when you're trying to determine if somebody's being discriminated against because of their sex.
Let me give you a not hypothetical case. An airline hires only women as cabin attendants, but it fires them if they marry. The airline's defense is, whatever we're doing, it's not sex discrimination against women because we don't hire any men at all, married or unmarried. That case, I take it from your brief, you would say there's no violation of Title VII.
Well, no, Your Honor, because I think the problem is that the prohibition on hiring any male flight attendants would in and of itself violate Title VII.
But the male is not complaining. The complainant is the woman who was fired because she married.
Okay, so
the male complainant might have a very good case, but my case is the woman.
And my problem with the hypothetical is that the way it's constructed, there is, you know, presumably no men that have the job in the first place.
Remember what I said about fighting the hypothetical? Not a good move.
Now, if you say that, in theory, men should be able to have the job, then the question would be, would you also have fired men who were married? And if you only fired women who were married but not men who were married, that would plainly be a violation of Title VII because you're treating similarly situated people differently. But to finish my answer to Justice...
That's an impossible
that was me, I'm pretty sure.
to put into practice by taking out the sex.
May I just continue
Yes,
with
Your Honor.
it? The hypothetical is not hypothetical. It's Sprogus against United Airlines.
Mm-hmm.
And it was given and not challenged that they didn't hire men as cabin attendants.
Right.
But they fired this woman because she married, because she didn't look like Cheryl Flyme.
Right.
Once she married, she wouldn't be attracted to the male passengers. The Court of Appeals said Title VII was meant to strike out the entire spectrum of sex stereotyping. So if this woman was fired because she would no longer be so attractive to men if she is married, that's sex discrimination. And we don't have to have a male involved. This is a woman who was treated in a very stereotypical way. She is no longer young and attractive when she married.
Your Honor, I do think that the question is always, are you treating similarly situated men and women differently? There are times where issues of proof are very difficult. For example, in the Price Waterhouse,
he's ducking the question, and it's not to his benefit. He's ducked the question now twice, so he's floundering a little bit, guys. That's bad ducking. So yeah.
Case, Ann Hopkins was fired because she was aggressive, because she was rude to staff.
This was an actual case. This was an actual case, and it was given that no males are hiring and no male is complaining.
But, Your Honor, the way that actual case was resolved was because the woman had not brought her claim in a timely fashion on the sex discrimination piece. And so the way this court resolved that decision was it said, all right, she's being treated the same.
This case never came to this
Oh,
court.
all right. Then I guess I'm thinking of the wrong case.
United Airlines, Seventh Circuit.
General, could I go back to your opening statement and particularly to the second part of it? You talked about the history of Title VII and some of the subsequent legislative history. And I guess what strikes me, and I was struck in reading your briefs too, is that the arguments you're making, I would say, are not ones we typically would accept. For many years, the lodestar of this court's statutory interpretation has been the text of a statute, not the legislative history, and certainly not the subsequent legislative history. And the text of the statute appears to be pretty firmly in Ms. Karlan's corner.
For those of you who didn't pick up on that, Elena Kagan just called out the conservatives of the court big time. She just said, look, guys, look, conservatives, you guys have been insisting for years that what matters is the text. None of this pesky intent in history and stuff. And look, it's like, hey, we've been doing textualism, right? This is just the text, right? Hey, what do you think, conservatives, huh? You wanna do this because it's text? Oh, Elena, I feel that. Oh, I feel called out. Oh, that hurts. Oh.
Did you discriminate against somebody, against her client because of sex? Yes, you did. Because you fired the person because this was a man who loved other men. And part of that, and it only has to be part, we've made very clear there's no search for sole cause in Title VII. Part of that is you fired the person because he was a man. If he were a woman, he wouldn't have been fired. This is the usual kind of way in which we interpret statutes now. We look to laws. We don't look to predictions.
Hey, conservatives. Hey, all you conservatives. Hey, conservatives, this is how we're doing this now, right? This is how we interpret things, right? This is the rules. This is the rules. You keep telling us this is the rules, right? We look to text. We don't look to desires. We don't look to intent. We look to the text, right? That's what we do is text, right, conservatives? Man, Elena, it hurts.
We don't look to desires. We don't look to wishes. We look to laws. Why doesn't that mean your argument failed?
Because, Your Honor, I think that what our brief attempts to do, at least, is make a straightforward textual argument. The law distinguishes between sex and sexual orientation. Those are two different traits. And that's precisely why when Congress wants to prohibit discrimination based on sexual orientation, it doesn't define sex as including sexual orientation. It listed.
All right, this is actually a really good answer and goes back to what he was saying earlier. It's like, look, when Congress wants sexual orientation to be something distinct, they list it as a distinct thing. And so there are all these things where it's like, look, it must be distinct. It must be distinct because Congress keeps changing the law to add it as a distinct thing. There must be a distinction between the two. It's actually a really good line of argument. It's a very good rebuttal to Elena Kagan and Sotomayor's. So Elena Kagan laid out the groundwork, and Sotomayor gave that little tap there at the end, where Elena Kagan's like throwing down Sotomayor's. What do you say to that, conservatives? And he actually came up with a pretty good answer. It's like, when Congress wants these to be two distinct things, they say it as distinct things. They can't be one and the same. It's a good line of argument.
It's a different trait.
What is your response to the two comparator problem we've been discussing, and the fact that at least one contributing cause appears to be sex?
Well, Your Honor, a couple of responses. First, I don't think that one contributing cause is sex. I think that as long as you're treating gay men and women exactly the same regardless of their sex, the contributing cause is sexual orientation, not sex. And two, I think it reflects the fact that sex and sexual orientation are different traits. And if you do the analysis the way my friends on the other side suggested, you've completely eliminated the distinction between two very different traits, and you've essentially nullified Congress's very careful decisions in numerous other statutes to specifically protect sexual orientation and gender identities. We'll get to in the next case.
Is there anything in this record showing that the employers would not employ lesbian women?
Your Honor, in these cases, and this may have been a better question for my colleague, but I think in these cases the employers have denied, in the cases, the sexual orientation cases, the employers have generally denied that they discriminate based on sexual orientation. But all we know, did this go, the allegation is that person was discharged when he announced that he was gay. There's nothing in the record, as far as I can see, that there was a policy on the employer's part of discharging or not hiring lesbian women. I think that's right. I think basically the employer's defenses here were, one, I didn't fire him because he was gay, but two, if you think I did, Title VII doesn't prohibit discrimination based on sexual orientation. And if I could address lastly the point that the Chief Justice and Justice Alito were raising about so-called legislative updating that Judge Posner suggested. Here, I think that a judicial ruling would be particularly pernicious because when Congress seeks to expand the scope of Title VII's liability provisions, it typically couples that itself with an expansion of the religious employer's exemption to Title VII, precisely because issues of sexual orientation, like issues of gender identity, raise different issues from a religious liberty perspective. The employee's position here would only do half of that work. It would expand the scope of liability without giving any consideration to those religious liberty interests on the other side of the balance, and that is precisely why this is the type of issue that is better left to Congress than the courts. Justice Gorsuch, I want to make sure that I fully address your textual considerations, though, because I really do think it boils down to the fact that sex and sexual orientation are different traits. May I finish my answer? Sure. Title VII prohibits discrimination based on one of those.
Robert Zaz said, I didn't do it, but if I did, you couldn't prove it, and if I could, I couldn't be punished. Well, Robert, for whatever it's worth, the federal rules of civil procedure allow for attorneys to make mutually inconsistent arguments. It's in the rules. So it's perfectly ethical to say, I didn't do it, but if I did, it was okay. And if it wasn't okay, here's why I shouldn't be punished. So yeah, mutually inconsistent pleading is allowed for in the rules. So you're allowed to make arguments that contradict with each other as long as they are delineated properly. So yeah.
Traits. As long as you treat men and women who are similarly situated with respect to the other trait exactly the same, you're not, quote unquote, discriminating within the meaning of Title VII.
Thank you, counsel.
Thank you.
5 minutes, Ms. Karlan.
One of the reasons it always pays to go first is you get that rebuttal time. So she's got 5 minutes to sell us, guys. All right, 5 minutes. Let's see what we got.
Thank you. Let me start with the question that Justice Ginsburg asked, because I think it's illustrative of contemporary sexual orientation discrimination cases. Virtually none of them involve an employer, and neither of the cases before you does, who claims to have an across-the-board policy of firing both all gay men and all lesbians. What tends to happen, and this case is illustrative of this, is a man who also doesn't conform with some other gender-based stereotypes and who is gay gets fired, which puts them in exactly the position that Justice Sotomayor mentioned, which is really devilishly hard to figure out what's going on here. The second point I just want to leave the Court with is the entire argument on the other side depends on the idea that men who are gay and women who are lesbians are being treated the same. And that's just not so. Because if you look at what actually causes the problem, it's the man who says, I married my partner Bill. If any woman who worked there had married Bill, she would not have been fired. And he is. And you have to look, because the textual language tells you to, at such individual and not at the overall class.
Ms. Karlan, would you address the general's statement at the end? He goes back to the comparator should be a woman who a man who likes a man and a woman who likes a woman. You're trying to get to that.
Yes, I think he is varying two things there. One, he's varying the sex of the employee, and second, he's varying the sex of the person to whom the employee is interested. And if two things...
So give us an example from a case how you can't do that.
I'm not sure. Of course, you can do it, but you don't have to, because all you need to do is show that sex played a role here. And if the answer is, if a woman had come in and said, I like to date men, you wouldn't have fired her. And when a man says, I like to date men, you did. That's enough to show sex discrimination.
What if the decision maker makes a decision based on sexual orientation, but does not know the biological sex of the person involved?
Well, there is no reported case that does that, and I think the Court can wrestle with...
What if it happened? We've had a lot of hypotheticals of things that may or may not have happened. What if that happens? Is that discrimination on the basis of sex where the decision maker doesn't even know the person's sex?
And how do they know the person's sexual orientation?
Because somebody who interviewed the candidates tells them that.
And they're unable to tell anything about the person's sex. No. So this is Saturday Night Live Pat. As an example, right?
Well, I'm not familiar with that.
Okay.
But
which is the person named Pat, and you can never tell whether Pat is a man or a woman. I mean, theoretically that person might be out there, but here's the key.
Theoretically what?
Theoretically that person might be out there, but here's the key. The cases that are brought are almost all brought by somebody who says, my employer knew who I was and fired me because I was a man, or fired me because I was a woman. Somebody who comes in and says, I'm not going to tell you what my sex is, but believe me, I was fired for my sexual orientation, that person will lose.
Well, if that's the case, then I think your whole argument collapses, because sexual orientation then is a different thing from sex.
Of course it is. No one has claimed that sexual orientation is the same thing as sex. What we are saying is when somebody is fired...
Let me amend it. Your argument is that discrimination based on sexual orientation necessarily entails discrimination based on sex. But if it's the case that there would be no liability in the situation where the decision maker has no knowledge of sex, then that can't possibly be true.
If there was that case, it might be the rare case in which sexual orientation discrimination is not a subset of sex. But in the case where the person knows the sex of the person that they're firing or refusing to hire, and knows the sex of the people to whom that person is attracted, that is sex discrimination, pure and simple. And it's important to understand that, and this goes back to something that Justice Ginsburg asked during the opening argument, that discrimination against gay men and discrimination against lesbians is not one thing. And in 1964, if you look at the members of Congress's brief, they will tell you, if you looked in the dictionary, there was no phrase sexual orientation. That is a modern way of combining two kinds of discrimination. Discrimination against gay men, which goes back to Leviticus and the common law, and discrimination against lesbians, which was not part of Leviticus and was not part of the common law. Indeed, in 1964, there were only 16 states in the United States that clearly forbid some act in which lesbians could engage. So the idea that this is one large idea about sexual orientation discrimination in the abstract without reference to sex simply burks the history and burks the understanding. And if you look at the harassment cases, you will see why this is true. Gay men are harassed in a different way than lesbians. Thank you.
Thank you, counsel. The case is submitted.
Well, that was pretty good ending there. Like, she's basically saying, yeah, this has been a problem mostly for gay men, not gay women. Lesbians are not discriminated the same way as gay men. This is a gay men issue, so this is a men issue. That's a nice little ending there at the end. I do like it. I also like the wax. She's like, yeah, discrimination against gay men goes back to Leviticus, but not so much with the gay women. Nice. That's a nice touch. Funky Fudge 11 says thank you. Thank you, Funky Fudge 11. Generally, does the Supreme Court view opposing counsels as a means of getting a better view of the case or just as opposing parties? Well, I'll give you a couple things that are generally accepted as true. It is generally accepted as true that you cannot win in an oral argument, but you can most decidedly lose in an oral argument. So, and it is also generally accepted that judges are asking questions not really of the advocate, but are really asking questions of their other judges. So they're asking questions as a proxy, basically, to get to the other judges. So the advocate is there kind of as a tool, if you like, for one judge to use to address the other. So like the questions they're asking are meant to, in many times, elucidate answers to ask questions they think are in the other justice's head. So like, so some of these questions where I'm saying, well, when I said like Elena Kagan was asking a conservative question, or Sotomayor was asking a conservative question, she's asking a conservative question to elucidate an answer that is conservative in nature to basically barb at her conservative colleagues. So that's like why she would ask a question that way. I mean, at least in part. I mean, obviously she has other motivations beyond that. She has motivations to learn, but you know, these things are extensively briefed, and there's amicus briefs all day long. So it's generally accepted you cannot win oral arguments, you can only lose. And it's generally accepted that you are there to be used as a tool to get at other judges. So that's fine. It's part of the deal. But all things considered, very interesting stuff. Burke, I have no idea. Burke's the understanding. I don't know what that means either. Let's look it up together. Burke's. That's a word I did not know. Burke. Definition. No, that's not right. Burke. It's B-E-B-U-R-K. Burke's the understanding? Huh. British. Someone who's unintelligent, stupid, or silly. A fool, a befound clown. That doesn't seem right. Well, I don't know. It's a word I'm not familiar with, and the dictionary doesn't seem to really have it either. I guess if it's a foolish way to view the history and a foolish way to have an understanding. I don't know. Anyways, that's okay. We're going to move on to part 2. We're only halfway through the stream. Aren't you excited? I'm excited. So, hey, I don't know the word either. I'll tell you what I don't know. And some of you guys are asking, what is this case and what's this case? I'm like, I don't know. I don't know all the cases. Man, I know a lot of cases. I don't know them all. But this case has been, like by the time you get to this level, there have been briefs and research and many, many briefs. And so, like, they know the case is cold. I don't know the cases. I haven't been studying this for the last 6 months, unlike the guys who've been arguing this. So let's move on to part 2, Electric Boogaloo. This is the oral argument so that was 2 cases for the price of 1. That was 2 cases consolidated dealing with sex discrimination. This is a case dealing with sexual orientation discrimination. Apologize. This is a case dealing with transgender discrimination. Just to make things even more interesting. So let me see if I can find a summary of this. I deleted my summaries, didn't I? Because that would, nope, I put them over here. No. Whether Title 7 prohibits discrimination against transgender people based on their status as transgender or sex stereotyping under Price Waterhouse versus Hopkins, which is, again, a case I don't know because I don't know all the cases. I do what I can, but I don't know them all. Let's see if I can get a summary of what this case is about. Okay, so here we are. The petition for review is filed by a small funeral home in Michigan owned by Thomas Rose, who describes himself as a devout Christian. Funeral home hired some person whose employer lists him as a man. 6 years later, He identified as a woman and wanted to wear a woman's clothing. He fired him because he believed that allowing him to wear women's clothing would violate the funeral home's dress code and be violating God's command by allowing him to dress in women's clothing. So that, yeah. I don't know all the cases. How shameful. I do what I can. All right, guys, I do what I can. But yeah, so we're firing a guy because he identified as a woman and is dressing up in women's clothing. Now we know everything we need to know. Let's figure out if this is illegal or not. We're now going to listen to oral arguments in this case.
We'll hear argument next in Case 18-107, R.G. and G.R. Harris, Funeral Homes versus the Equal Employment Opportunity Commission. Mr. Cole?
Mr. Chief Justice, and may it please the Court. Amy Stevens is a transgender woman. She was a valued employee of Harris Funeral Homes for 6 years until she told her boss that she was going to live and identify as a woman. When Harris Homes responded by firing her,
someone asked, when will these cases be ruled on? Well, 99% of the time, or 99.5% of the time, they will be ruled on before the 1st of July. When exactly, I can't say, but the Supreme Court meets from the first Monday in October, which obviously just happened this week. So this was the first week that's back in session. It meets from the first Monday of October until the last day of June. So it can render a decision anytime in that time frame. Now, obviously, this is really early in the session. So if I were a betting man, I would bet it's going to issue its decision in this case probably around February. Best guess. But the Supreme Court does not announce in advance when it's deciding a case. You only know when they're going to decide when they decide. So at 10 a.m. in the morning, they walk in and say, we have decisions in these cases, and that's when you know. The only other time you can know is if it's the last day of the session. And I actually pulled this trick once with the Obamacare cases because I think it was like the second time the Supreme Court heard the Obamacare cases, and they hadn't decided it, and it was the last day of the session. So I took it as probably a pretty good shot they were going to announce it that day. So I was actually in the Supreme Court when they announced that decision, which was pretty cool to be in. When Chief Justice said that it was not okay because of Commerce Clause, or it was okay because of taxing authority, I was there, man. I was there in the room when that happened, man. It was pretty awesome. So, yeah, when will they announce? Man, 4 months. Take your guess.
Discriminate against her because of her sex for 3 reasons. First, in firing her for failing to conform to its owner's explicitly stated stereotypes about how men and women should behave, it discriminated against her in the same way that Price Waterhouse discriminated against Ann Hopkins for failing to walk and talk more femininely. It can't be that Ann Hopkins would lose her case on the same facts were she transgender.
No, the court did not rule on whether half of Oklahoma is an Indian reservation yet. That would fall into the 0.5% category. They held that argument over. They ordered re-argument. So they're arguing it again this session, and the re-argument hasn't occurred yet. So yes, is half of Oklahoma Indian reservation fell into the category of the 0.5% of cases that aren't decided by the end of June. So there's your exemplar of a case that was not decided. So we're going to have re-argument at it again because we couldn't decide the first time. So yeah.
Second, Harris Holmes fired her for identifying as a woman only because she was assigned a male sex at birth. In doing so, it fired her for contravening a sex-specific expectation that applies only to people assigned male sex at birth, namely that they live and identify as a man for their entire lives. That is disparate treatment on the basis of sex. Third, Harris Holmes fired her for, in its owner's words, changing her sex. That's discrimination in the same way that firing someone for changing their religion would be religious discrimination. That Harris Holmes would fire both transgender men for being insufficiently feminine and transgender women for being insufficiently masculine is, as the government concedes, 2 acts of sex discrimination, not a defense. None of these arguments ask this court to redefine or in Judge Posner's words,
Poor Judge
update
Posner. Poor
sex.
Judge Posner.
They assume arguendo that sex means, at a minimum, sex assigned at birth based on visible anatomy or biological sex.
I understand that as the argument, and I believe it's the same as in the prior case. But does that argument hold up when you get to specific work requirements? In other words, if the objection of a transgender man transitioning to woman is that he or she should be allowed to use the women's bathroom. Now, how do you analyze that? I understand how you analyze status, as it were, and maybe that's hiring and firing on the basis, treating it as just on the basis of sex. But when you get to specific policies, does that hold true?
So first of all, Your Honor, how you answer this case will not resolve how you answer that case. Whether you rule against us or for us, the next case will arise in the following sense. A dress code that distinguishes on the basis of sex obviously is because of sex. The question then is, does it impose a discriminatory term and condition? And as this Court said in Burlington Northern, to discriminate is not just to differentiate, but to differentiate in a way that injures.
No, I think you're missing my point, maybe because it wasn't carefully expressed. But it's can the claim be? I mean, I understand you say you're dealing with transgender status and you can't discriminate on that basis on the basis of status. But when you get to the actual policy, do you analyze it as discrimination on the basis of sex, carrying forward your reasoning at the outset, or on the basis of transgender status? So if the objection of the transgender individual is that I want to use a bathroom consistent with my gender identity rather than biological sex, do you analyze it as the affecting based on the transgender status, or do you analyze it on the basis of biological sex?
So I think our argument rests on biological sex, or what we think is more accurately referred to as sex assigned at birth. But here's the thing: if there is this case asks whether when someone fires someone because they're transgender or because they fail to conform to sex-based stereotypes, is that because of sex? That's what this case asks. Obviously, a sex-specific restroom policy is because of sex. So we're not answering that question. It's because of sex. Then the question
now, just if I could interrupt so I can follow, it's because of sex.
Because of biological
but
sex.
if you analyze it because of sex, then I think has been pointed out, there's no disadvantage whether you're a man or a woman. But if you analyze it on the basis of transgender status, there is, because you want to use the women's restroom and be biologically male. So when it's analyzed on the basis of sex, there's no problem. But when it's analyzed on the basis of transgender status, it presents a whole different case.
So I don't think so, Your Honor. I think, look, anybody can challenge a sex-specific rule. A transgender person can challenge a sex-specific rule. A non-transgender person can challenge a sex-specific rule. What this Court said in Burlington Northern and in Oncall is that to decide whether something discriminates that refers to sex is you have to ask whether, not just whether it differentiates, but whether it differentiates in a way that injures. And you answer that question by asking, would a reasonable person in the plaintiff's position experience a significant or a trivial harm? Now, in most instances,
that's the question I posed to Ms. Karlan earlier.
Right.
And we went around the tree a bit, but ultimately came to, I believe, a submission that a reasonable person in the transgender plaintiff's position would be harmed if he or she were fired for failing to follow the bathroom rules or some sort of dress code that's not otherwise objectionable, along the lines of that were present in the facts of this case, where men and women had rather traditional options available to them. But so is that your answer as well?
That is my answer, and here's why. Let's say we have a sex-specific dress code, and you require me or you to follow the male dress code. Most instances, that's not going to be a significant harm. That's going to be a trivial harm, as the Court talked about it in Burlington Northern. Therefore, it's not discrimination, even though it differentiates on the basis of sex. But if you ask you or me to dress as a woman, we would consider that a significant harm. And when you ask a transgender person to dress in a way that is contrary to their sense of gender identity, you have imposed a significant harm. And the harm is because of sex, based on biological sex, as Chief Justice Roberts.
Mr. Cole, let's not avoid the difficult issue, okay? You have a
so far he's been dodging the issues a little bit in a way that I kind of find is disingenuous. So Sotomayor, I think, is right to call him out here. He's avoiding these questions, and you look to injury, and you look to what the law considers injury, and the bathroom example is a particularly good example because it's one that people resonate with the most. For better or worse, it's one that people resonate with. So it's one that most crystallizes, or it crystallizes the issue. And so she's like, well, let's not avoid it. Let's tackle it. So I think she's right to call him out. He's been dodging it a little bit in ways that's disingenuous so far.
Transgender person who rightly is identifying as a woman and wants to use the woman's bedroom. Rightly, wrongly, not a moral choice, but this is what they identify with. Their need is genuine. I'm accepting all of that. Yep. And they want to use the woman's bathroom. But there are other women who are made uncomfortable, and not merely uncomfortable, but who would feel intruded upon if someone who still had male characteristics walked into their bathroom. That's why we have different bathrooms. So the hard question is, how do we deal with that? And what in the law will guide judges in balancing those things? That's really what I think the question is about.
Well, that is a question, Justice Sotomayor. It is not the question in this case.
Mr. Cole, that's yes. Because once we decide the case in your favor, then that question is inevitable.
No, I think even if you decide the case against us,
it may not be if they're single-sex bathrooms, there might be one answer, meaning what harm would the other women, reasonable women, feel if a man's using a single-sex bathroom. Might be another if it's two locker rooms, men and with girls and boys, and who walks in is something you can't control. That's what the question is.
But Justice Sotomayor, the reason deciding this case will not decide that case, because
it won't decide.
It won't decide. Even if you rule against us, that case can arise because it is a sex-specific rule, and anyone who is affected by a sex-specific rule can argue that it discriminates against them because a reasonable person in their shoes would experience a significant harm.
Well, I understood you to say, maybe I didn't understand you correctly, that if your client had been fired for using the woman's bathroom, that would be a violation of Title VII.
So what I said was, yes, in our view, were we litigating that case here, which we aren't, they admitted that the restroom was a hypothetical issue and not a reason why she was fired. But were we litigating that case, I think the question would be not whether the policy was because of sex, which is the question here, because obviously the restroom is because of sex. The question would be, does imposing that restroom policy, which is obviously because of sex, impose a discriminatory injury on an individual? And again, if you require me to go to the women's restroom, that's a serious...
So what you're saying is that we're stuck with that question regardless of how we decide this
case. Whether you rule for or against us.
But the difference is that part of the argument, at least, is that the term sex includes sexual orientation. And if that is the case...
Cody Sam says, I'm confused. She's saying, if we say yes, we'll get to this question. And he's saying, if you say no, you'll get the question anyway. Why do we either have the burden of a future question on the case? Well, the reason is because we have a common law system and we build on precedent. And so we're saying that, look, we're about to put a brick down on this wall. And once we put a brick down on this wall, we're going to build other bricks on it. And what's going to happen next? So it's asking what are some consequences that are foreseeable of our decision. It's like, all right, here's where this is going. And it's like, what are we going to do with it down the line? So it's perfectly reasonable to say, if we lay this brick down here, what's going to happen next, and how are we prepared about that? Because you have to, it's thinking ahead, right? It's trying to apply a little bit of reasoning, a little bit of logic, and say what's going to happen down the road, and saying, look, if we say this, here's a line of argument that's going to come. How are we going to deal with this problem? And so, to me, it's perfectly legitimate because it's a foreseeable issue. So, yeah.
If we analyze the bathroom,
oh, you lost the banner. I
purely on the
apologize
basis
because I scrolled up. So I will put it back down so you can see the banner. Ta-da!
Biological sex, maybe you have one answer. But if you analyze it in terms of transgender status, you have a different answer, because men and women who identify with their biological sex aren't disadvantaged whether they use the men's room. They each can use their own restroom. But the issue is quite different if you're dealing with a transgender individual who wants to use the restroom of their gender identity, contrary to their biological sex. And the question is, how do you analyze that? You say in each case it's on the basis of sex. Do you analyze it on the basis of biological sex, or are you analyzing it on a different basis? Because they present different issues.
Your Honor, for purposes of this case, all we are arguing is that Title VII's reference to sex at least includes what you're calling biological sex, what we call sex assigned at birth.
Mr. Cole, you can go further than that for purposes of the.
I think it is a tactical mistake to reframe this by saying what you call sex assigned at birth, what we call sex assigned at birth, or what you call biological sex. It's like, I think it's a tactical mistake. Look, it's like, whatever you want to call it, the Supreme Court, you're correcting the Supreme Court's language in a way that's not helping your case, right? You're already having a tough enough time with the language of sex at birth, and now you're talking about sex assigned at birth. You want to reframe that language. It's like, I think you're doing your cause a disservice. The conservatives are already antsy about this, and now you're like, well, what we call is sex assigned at birth. It's like, really? The Chief Justice just asked you a question, and you want to reframe it as sex assigned at birth? It's like, you really want to do that? I think you're doing your cause a disservice with this language. I mean, you're not winning any points by this.
Next case, all it includes is biological sex as well. All that you're saying is, yes, that because of sex means because of biological sense, regardless of whether the transgendered person or whether a non-transgendered person brings this claim about the restroom.
Okay, so then it's an easy case, right? Because if it's
Cole says, I mean, wouldn't it have the same connotations, bricks and all? Framing the language can mean a lot in future cases? Yes. Yes, it always means a lot in every case. Yes, what happens next always means a lot, especially when you're the U.S. Supreme Court, right? Especially when you're about to make a decision that's about to guide the courts of appeal and the district courts for time immemorial going forward. So yes, it's always a relevant issue. It's like, what's going to happen next? So yes, this brick that we're about to lay down is always an issue. Always an issue. And so, it's perfectly legitimate to say, wait a second, this brick, it's exactly why you can't say it to a court, let's just make an exception this one time in this one case. It's like, no. You can't do that. No. You can't. Don't. And everyone screams. I think I'm ripping off an XKCD cartoon, by the way, when I'm saying this, because I think this is their idea. It's like, no. Don't lay that brick down over there. Don't you see what's going to happen? It's like, that's how courts go, man. It's always an issue what's going to happen next.
Just biological sex, there's no problem because there's no disadvantage. But if you're looking at transgender status, there's a huge problem because it's not biological discrimination, or the claim is going to be different. Certainly a transgender individual can bring the claim under Title VII that it discriminates on the basis of sex.
Right.
But if the claim is it discriminates against me because I'm a transgender individual, that's not your claim.
But that's not the claim here is that you are treating.
He's doing it again.
That Harris Holmes is treating Amy Stevens differently because of her sex assigned at birth.
That sex assigned at birth language is really, really not doing him favors. Really not doing him favors. He should just keep with sex. It's like, it's really not doing him favors. I mean, he was having a tough time already because he's asking to move the law, and conservatives like, as I say, conservatives like things in boxes. We like things that are compartmentalized and understood. We like boxes. We like things that are understood, and we like our little boxes we can put in. And it's like now you're fighting them on language on top of everything else. I mean, you're killing your argument. It's, oh my word, you're virtue signaling to a court. This is not good moves.
If she had a female sex assigned at birth, she would not be fired. Because she had a male sex assigned at birth, she is fired. That is discrimination because of sex. That's all and that doesn't decide the bathroom question, because the bathroom question, there's no doubt that separate sex bathrooms are because of sex.
Because of biological sex.
Because of
You guys remember what I said at the end of the last stream, or the end of the stream from the previous argument? You remember what I said about the general consensus of oral arguments? You remember what I said? I said the general consensus is that you cannot win an oral argument, but you can lose an oral argument. This would be an example of what I'm talking about. Just in case you wanted to know, this is an example of the second half of that, what that looks like. Yeah.
Biological sex as you use it, because the question then is, does it impose a de minimis burden, a trivial burden, as the court said in Burlington Northern, or does it impose a significant burden? In Burlington Northern, the court said the same rule can impose a significant burden as to some people and a trivial burden as to others. A schedule change might be trivial for a worker with no kids, but a worker with kids would be significant.
I imagine you would say that excluding a transgender woman from the woman's bathroom would be far more than a de minimis burden on that person. But let me move out of let me move beyond the bathroom to another example, and it's not before us, but it will be coming. So a transgender woman is not permitted to compete on a woman's college sports team. Is that discrimination on the basis of sex in violation of Title IX?
So Title IX is a different statute with regulations that explicitly permit sex-segregated teams when competitive skill or contact sports are involved. So again,
but this is a question of someone who has transitioned from male to female,
right,
and wants to play on the female team. She's not questioning separate male-female teams, but she was born a man. She has transitioned. She wants to play on the female team. Or does it violate Title IX, which prohibits gender-based discrimination?
Right. And I think the question, again, would not be affected even by the way that the court decides this case, because the question would be, is it permissible to have sex-segregated teams? Yes, where they involve competitive skill or contact sports. And then the question would be, how do you apply that permissible sex segregation to a transgender individual? And it may be that because Title IX recognizes concerns about competitive skill in contact sports, that it's permissible. It may be that it's not permissible. But this case just asks, when you fire somebody because you say he was going to represent himself as a man, because she was using the name Amy, and that's not permissible because he's a man, is that sex discrimination? Yes, that is sex discrimination. Whether when you have a policy that permits sex segregation, how that applies to transgender people is just a different question. It is not answered one way or the other by this case. You would still have to ask, is it fair to keep that person off of the team, just like it's fair to keep a man off of that team? The stereotypes in this case
right now
are every bit as strong as they were in Price Waterhouse. In fact, they're stronger, because in Price Waterhouse, you had to infer from statements that non-decision makers were making about why Ann Hopkins was fired. Here, Mr. Rost has made his sex stereotypes absolutely clear. And the government and petitioner concede that transgender people are not excluded from the statute. It's not like the German police officer. They concede transgender people can bring sex discrimination claims. She has brought a sex discrimination claim because she was fired for failing to conform to sex-based stereotypes explicitly stated by her employer. That it can't be. Again, Ann Hopkins would lose her case were she transgender. It's not okay to employ sex stereotypes against an employee until that employee becomes transgender. And at the end of the day, the objective...
Guys, I know this might be a little difficult to appreciate if you haven't been there, but he's talking way too long. No one's interrupting him with questions. And when that happens, that's a really, really bad sign. He's been talking way too long without being interrupted. And so, like, the fact that this is still going and we haven't even gotten to the bottom and he's still talking without interruption, it's like he's lost the argument, basically. No one wants to ask him anything anymore. And now he's just talking because no one wants to ask him a question. It's like, oh, man. It's like, it's a pretty solid sign it's game over when that happens. It really is. It's like, wow, it's game over. And now he's just talking to no one. No one cares.
To someone for being transgender is the ultimate sex stereotype. It is saying, I object to you because you fail to conform to this stereotype. The stereotype that if you are assigned a male sex at birth, you must live and identify for your entire life as a man. That is a true generalization for most of us, but it is not true for 1.5 million transgender Americans. And so to say, we're going to fire you because you fail to accord to a generalization about how people who are assigned a particular sex based on visible anatomy at birth have to live their lives for the rest of their lives is sex discrimination. It's also sex discrimination because she was clearly treated differently because of her sex assigned at birth. Imagine an employer who had 6 Amy's, and he invited all 6 Amy's in, and he said, I just want to know what your sex assigned at birth was. And 5 of them say, well, I was assigned female at birth. And 1 says, I was assigned male.
Oh, my God, he's still talking.
And then he fires the one who says, I was assigned male at birth. Obviously, that person is fired because of her sex assigned at birth. And as we saw from the prior argument, it need not be the only justification. It need be only one justification.
Oh, thank God. Someone's about to ask a question.
And the notion that somehow discriminating against someone because they're transgender
please let's
is
stop.
not discrimination. Discriminating
like
against
2
them
minutes
because
or
of their
something?
sex,
No one asked
I
the
think
question?
falls apart because to say I'm discriminating against you because you are transgender is to say I am treating you differently from other people who have the same gender identity because of your sex assigned at birth. So again, we're not asking that you update the statute. We're not asking that you redefine sex. We are accepting the narrowest, for purposes of this case, the narrowest definition of sex, and arguing that you can't understand what Harris Holmes did here without it treating her differently because of her sex assigned at birth.
There seems, Mr. Cole, to be this dispute among the parties in this case.
All right, how long did that go on, guys? I mean, let's scroll back up. Just take a look at this. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20. Like 20 paragraphs. Elena Kagan finally with a mercy question. I don't even know if she cares about the answer as much as she's just trying to show mercy at this point. Only God.
As to what the basis of the firing was, whether the basis of the firing was the violation of the dress code particularly, or whether it was broader than that, was being transgender. What should we make of that dispute?
Well, I mean, the Sixth Circuit expressly said that the reasons for firing her extended beyond the dress code. Counsel for Harris Holmes conceded at oral argument in the Second Circuit that she would have been fired if she showed up as a woman, even if she were following the dress code, and that's in Petitioner's Appendix 66A from the Sixth Circuit decision. And he fired her after he got the letter saying, I am coming out as a woman and I'm going to heretofore be called Amy, without any discussion of the dress code whatsoever. So this is the case.
So, Mr. Cole, though, your argument, though, doesn't turn on that. I mean, as I understand it, again, that if the firing had been solely what the employer claims, the basis of the dress code only, the result would be the same. And I guess I'd just like you to have a chance to respond to Judge Lynch and his thoughtful dissent, in which he lamented everything you have before us, but suggested that something as drastic a change.
So I think we've so far seen varying levels of Supreme Court quality, right? So the first woman who spoke in the prior case, she was by far the best, right? We'll all agree on that. She was really solid. Solicitor General was very good. Not as good as the woman, but he was good. And then that other guy wasn't good. And this guy's last. I mean, he's fumbling around. And he lost it on the language argument. He lost it by talking about sex assigned at birth, in my opinion. It was a total tactical mistake. And yeah, someone said it was 5.5 minutes. It's like, it felt that long. It's like, why are we even discussing it for that long? It's like, well, they give you a half hour per side. Unfortunately, he won't sit down. So, like, we're only 20 minutes into this. He's gotten there 10 minutes. So, oh, Jesus Christ. I mean, can you believe it? He's been only talking for 20 of his allotted 30 minutes. Remember the woman? She was ready to sit down after 4. She was ready to sit down after 4 minutes because she was done. And this guy's been talking for 20 minutes, and he's talking crap. And he's got 10 more minutes left, and he's going to use it all, isn't he? Oh, my word. Let's carry on.
In this country as bathrooms in every place of employment and dress codes in every place of employment that are otherwise gender neutral would be changed. That's an essentially legislative decision.
Your Honor,
Judge Lynch is a very thoughtful judge and wrote a very thoughtful opinion that I think he probably regretted having to write. What do you say to him?
I say that recognizing that transgender people have a right to exist in the workplace and not be turned away because of who they are does not end dress codes or restrooms. There are transgender lawyers in this courtroom today.
Of course there are. That's not the question, Mr. Cole. Mr. Cole, the question is a matter of the judicial role and modesty in interpreting statutes that are old. And that's the question he posed.
Right.
Nobody is questioning, and he certainly did not, the legitimacy of the claims and the importance of them.
So I think
the question is a matter of judicial interpretation.
Yeah, there's
if you wish to address it.
Two answers to that, Your Honor. First, on the question of judicial interpretation, we are not asking you to apply any meaning of sex other than the one that everybody agrees on as of 1964, which is sex assigned at birth, or as they put it, biological sex. We're not asking you to rewrite it. Second.
I agree with that.
Second.
The question, though, again, I'm sorry to pose it, but I'm going to give you one more shot.
Yeah.
All right. When it came
Okay, you know you're in trouble when the judge is asking you the question for the third time. If you didn't know you're in trouble from the 5 minutes you were allowed to talk with no one interrupting you, I wonder if he was secretly thinking to himself, why is no one asking me questions? Because that's what I would be thinking. It's like, well, it's been way too long. But let's see if he gets it right on try number 3. What do you got, Neil?
This is really close. Really close on the textual evidence. And I assume for the moment, I'm with you on the textual evidence. It's close, okay? We're not talking about extra textual stuff. We're talking about the text. It's close. A judge finds it very close. At the end of the day, should he or she take into consideration the massive social upheaval that would be entailed in such a decision and the possibility that Congress didn't think about it, and that is a more effective.
Even Marshall says letting him finish the question would be good, though. Like, it is well accepted practice that if the judge is talking, you stop talking. You stop talking for as long as they talk. They get to interrupt you. You don't get to interrupt them. And it's bad practice to try to interrupt the judge. You just sit there very quietly and let them ramble as long as they're going to ramble. It's just the way it goes. If they eat all your time, they eat all your time. That just sucks to be you. But man, oh Lord, it's the least of his problems is the fact he keeps interrupting the question.
Appropriate legislative rather than a judicial function. That's it. It's a question of judicial modesty.
So, first of all, federal courts of appeals have been recognizing that discrimination against transgender people is sex discrimination for 20 years. There's been no upheaval.
Ewan Marshall does point out that I flipped what you said. He said, let him finish the answer to the question, not the question. You're right. I misread what you said. I apologize for putting words in your mouth. But yes, letting him finish the answer to the question. I misread what you wrote. I apologize.
As I was saying, there are transgender male lawyers in this courtroom following the male dress code and going to the men's room, and the court's dress code and sex-segregated restrooms have not fallen. So the notion that somehow this is going to be a huge upheaval, we haven't seen that upheaval for 20 years. There's no reason you would see that upheaval. Transgender people follow the rule that's associated with their gender identity. It's not disruptive. And as to whether this is a question of interpretation, it is absolutely a question of interpretation. How in the world can the court interpret Title VII to say that Ann Hopkins can't be fired for being insufficiently feminine, but my client can be fired for being insufficiently masculine? There's no textual basis for drawing that distinction whatsoever, and that's because our argument rests on text meaning, at a minimum, sex assigned at birth or biological sex, and everybody agrees.
Did you want to address Judge Lynch's arguments or not?
So we asked the question for the fourth time. Do you want to talk about what Judge Lynch said or not? Apparently not is the correct answer.
I thought I was. Number one, it's not disruptive that transgender people exist in this world and we still have sex-segregated dress codes. And number two, it's not asking you to address a policy question that would be more appropriate to Congress, but asking you to interpret the statute as it is written and as everybody agrees it applies to sex assigned at birth. Thank you.
Thank you, counsel.
Oh, good. It's ever. Laura, let's see if side number 2 has anything better to say. You know, there's a line from Frasier one time where Frasier's doing a call from some guy who's asking what to name his yacht. And Frasier says, you know, at Caltech, there's this thing called the tunneling electron microscope. It's used to study the smallest particles of the universe. And if I had that right now, I still couldn't locate my interest in your problem. That's about how I feel about this guy right now. It's like, I long since ceased to care about anything you have to say. Let's see if side number 2 can do any better. It'd be hard not to, but let's see what we got.
Birch?
Thank you, Mr. Chief Justice, and may it please the Court. Treating women and men equally does not mean employers have to treat men as women. That is because sex and transgender status are independent concepts. Now, in the context of this case, Title VII gives Tom Ross the ability to consider how enforcement of a sex-specific dress code would impact all his employees and grieving clients. But the Sixth Circuit imposed a new restriction, and its holding destroys all sex-specific policies and even BFOQs while undermining the protections that Title VII provides. If you accept at face value Stevens' concession that sex means biological males and females, then the funeral home wins. So my friend Mr.
Someone point out that you don't see the bottom of the text. The rule doesn't quite apply at the start of the argument. Sometimes the justices are very quick on coming in, but usually they'll give you a little bit more slack when you first start. So usually you get a minute and a half before they ask the question, maybe 2, maybe 10 seconds, but you get a little bit more slack. So the rule doesn't apply when you first start talking. BFOQs are bona fide occupational qualifications. So in the issues of discriminating against sex, you can discriminate on the basis of sex under current law as long as the reason you're doing so is a bona fide and actual reason. And the classic example would be a female guard to physically search a female suspect. It's a bona fide reason to discriminate on the basis of sex. So that's a BFOQ. Let's carry on.
Redefine sex to include transgender status in 2 respects. First, my friend's but-for test would mean that a woman's overnight shelter must hire a man who identifies as a woman to serve as a counselor to women who have been raped, trafficked, and abused, and also share restroom, shower, and locker room facilities with them. That is because, but for the man's sex, he would be allowed to hold that job and to use those facilities. The purportedly simple test does not get to the ultimate inquiry of whether men are being treated less favorably than similarly situated women because of sex. That does not reflect the original public and legal meaning of a statute promoting women's equality. Second, under my friend's stereotyping logic, it is always illegal stereotyping to apply sex-specific policies based on biological sex. And that's why he's wrong to say this case isn't about showers and overnight facilities and sports. Every single one of those is impacted if you're talking about a sex-specific policy. What Title VII says is that sex-based differentiation is not the same as sex discrimination. And that's why Ms. Karlan agreed that this Court's sex-specific dress policy doesn't violate Title VII. And though Congress has added classifications to cover transgender status in other statutes, it has rejected more than a dozen proposals here. Title VII.
The first part, you've made the argument, which I call the parade of horribles argument, that you've heard, as I have for the last hour and a half, the response, which is that isn't this case, that many of the things that you are worried about would be taken care of by bona fide occupational qualification, that other of those things would be taken care of by the need to show harm as well as to show difference, and that there could be, though we haven't done.
The parade of horribles is also just reductio ad absurdum. It's also called post hoc, or it's what other thing. It's just it's basically, because you did this, here's a whole bunch of other horrible things that will happen. Because we legalize whatever, then 8 billion other things will happen. It's basically the slippery slope fallacy taken to the extreme as parade of horribles. So parade of horribles is slippery slope. It's basically all the same thing. Parade of horribles is another name for it. I kind of like it personally.
And I'm not advocating it, yes or no, the possibility of bringing into such cases comparative harms. And all those things are open. And if you say that the lower court decided them, this is not the lower court. I take it that we are deciding simply whether it falls within the words sex discrimination, and if it does, we are not saying whether there has been harm, whether there has been a BFOQ, whether there is comparative harm, etc. That's what I've heard. Now, what do you say to that?
Justice Breyer, that is incorrect.
Yeah, so someone asked, is slippery slope, parade of horribles, reductio ad absurdum a logical fallacy? Well, it is and it isn't, and it more isn't in my view. It is a logical fallacy in so much as to say that because we did A, it doesn't logically mean that we have to do B. However, because we did A, it makes it much easier to do B. Because we work on a common law system, because we work on precedent, and because it builds the brick in the wall for the next thing. So it's like, yes, it's not strictly speaking that because we did this, we have to do this. But everyone recognizes, because we recognize work in a common law system, that if this becomes a precedent, it will be built on and it will grow over time, as they all do. And it will not stop here. It never does. So strictly speaking, it is a logical fallacy because it doesn't have to be true. But most of the time, it's not a logical fallacy because it probably will be true at some point in the future, because that's how a common law tradition works. So I tend to think people who say slippery slope is a logical fallacy, I don't like that argument. It tends to be more often that it's not a logical fallacy. It tends to be more often that it's a foreseeable, reasonable thing of things that might follow in the common law tradition. Especially when you're the Supreme Court and you're trying to think 50, 100, 150 years down the future, which is hard for anyone, but you're trying to think about what the future is going to have. If you do this now, what will the future hold? These are reasonable arguments.
Because when a biological male is refused access to the women's restroom, the male would say that was an injury.
Yes, of course he would say
and there is no BFOQ.
And the other side would say, I'm sorry, but there are serious injuries on the other side. And therefore, it is a BFOQ, okay? And so this is not that case. We do not have to decide it. And I don't see why or how you can assume the answer and then build your argument on an answer that I certainly haven't given.
It's their answer, and here's why. If Stevens is right that you cannot apply a sex-specific policy to those who identify as the opposite sex, then you cannot apply that policy to anyone, because that itself would be sex discrimination.
All right. Just on the off chance that I feel we do not have to decide that matter in this case, have you other arguments that would favor your side? I know you do, and I just at some point to hear them.
Certainly. Their comparator is a man violating the dress code with a woman who follows the dress code. That is wrong. Our comparator is a man who violates the dress code with a woman who violates the dress code. Now, the reason we know theirs is wrong, because if you were claiming transgender status discrimination rather than sex discrimination, you would compare a transgender and a non-transgender employee, which is exactly what they do, which proves that they're adding a different classification into the statute that Congress has not added.
And what they say is the reason we know you're wrong. I'm not saying this, nor am I assuming any other person thinks this. I'm just saying that this is what I hear, that if you are right, then miscegenation does not fall within this statute, that Jews marrying Catholics does not fall within this statute, that any instance where people say, or many instances where they say, I fired this man because he wasn't a woman, I fired the woman because it's a man's job, it's okay, as long as sometimes you'd fire a man because it's a woman's job. You see the point.
I do. Justice
okay.
Breyer?
Now, what is your answer to that?
There is no non-racist reason why you would fire the employee in the interracial marriage. There is no non-religious...
I happen to know, I won't say who they are, but there are people in my life I have heard say, being Jewish is fine. Being Catholic is fine. Just don't get married.
But that's a religious reason. Now, in this case...
Right, but does that mean it falls outside the statute that forbids discrimination because of religion?
Yes, because Title VII allows you to recognize that there are differences between women and men.
Look, guys, when you see laughter, you just have to bear in mind, okay, it's U.S. Supreme Court, guys. It's a very tense situation. So what passes for humor at the U.S. Supreme Court will not work at your local comedy club, I'm sad to say. But everyone is very, very tense, and so it doesn't take much to get a bit of a laugh. So the standard is kind of low for humor at the Supreme Court. It's an easy room if you want to get a laugh, although they make a very strong point of putting it in the guidelines for the attorneys. And I cannot emphasize how good an idea this is. Whatever you do, do not try to make your argument funny. Do not try to elicit a laugh. Do not try to tell a joke. It will fail horribly. It is a horrible, horrible idea. I have never, ever, ever seen it work where a person tries to elicit humor. The humor is organic from the situation. If you try for it, it goes so cringy, it is truly hard to believe how cringy it is. Do not ever, ever try to tell a joke. It will not work. There's your pro tip for the day.
And that an employer, switching back to the first case, could terminate a same-sex couple or an employee who's married to a same-sex partner, maybe because they are Catholic and they believe that marriage is only between one man and one woman, and sex doesn't have anything to do with it. Let me give you an example here.
That's a ministerial exception that already exists.
A ministerial exception if the employer is a church, but not if the employer is a Christian businessman like Mr. Rost.
But there's still religious exceptions that the court has read into a lot of statutes. Putting that aside, your example, very powerful. Women in a shelter who you say, if we accept his argument, will have to be guarded by or counseled by a transgendered woman. But isn't that exactly like Dohart? And there we said you can't have sex-specific guarding of prisoners unless you have a BFOQ. And there they found that it was a BFOQ to make only men guard men and women only guard women. So I'm not quite sure that I understand your parade of horribles.
Because under Mr. Cole's theory, BFOQs have to go too. Say that you have a BFOQ that
but
says...
But it's statutory. They can't wish it away, but go ahead.
If you have a BFOQ that says only a man can apply for this position, he would say that a woman who is transgender is a man and therefore is eligible for that position, and no BFOQ in the world would be able to keep them out of that position. The problem is they're adding transgender classification to a statute where Congress has never added it.
No, what they're doing is saying if there is an independent reason why a man who's transgendered can't have a job that a woman has, then that reason is good enough. You don't have to hire them. But if there is no reason why your gender should marry in the work you're doing, why should you not be hired? That's a very different proposition.
Let's go back to the women's overnight shelter. Assume for a moment that the employer had a BFOQ that only women counselors would be able to counsel and stay overnight with the women who have been abused.
How does that fit with BFOQ? BFOQ is a very narrow category.
I agree, but they're applying it broadly, and I'm using Justice Sotomayor's example. Assume that there's a BFOQ for that and that someone would allow that. Their position is that it's stereotyping not to treat the man who identifies as a woman as a woman. They're arguing that but for the fact that they were born as a man, they could take that women's position. So there is no BFOQ, there is no religious requirement that would stop and draw the line at the argument that they're making. All of the distinctions between men and women are gone forever, and that's the plain text of the statute.
Do you wish to address Judge Flaum's argument, joined by Judge Ripple, which again is a very thoughtful position too, that there may be dual causes here, but the fact that sex is under consideration, even as narrowly construed, is enough to draw us within the statute?
I think that line-drawing inquiries happen all the time in Title VII, and it's entirely appropriate for a judge to instruct the finder of fact to draw that line. And the line that has to be drawn, based on Title VII's language, is whether women are being treated less favorably than similarly situated men because of sex. And sometimes it'll fall on the line, sometimes it won't. Consider
I think, Mr. Bursch, that's not quite right. Women should be treated less differently than men. You're making Title VII into a statute about groups. But Title VII is not a statute about groups.
That's helpful, but I'm also curious what you have to say, Mr. Birch.
Yeah, let's put both of those together. Individual and that concept. Say that you have a woman who identifies as a man, and they're working at an employer, and they get pregnant. They would be entitled to the same pregnancy benefits as any of the women at work, because that, if they didn't get it, that would be sexist. But if the employer applied a sex-specific dress code or sex-specific showers and restrooms, that would not be a statutory violation because of their biological differences. Men and women are not similarly situated, and no one is being treated disadvantageously compared to someone else. So you could have an employee who might have a sex discrimination claim, but they can't bring a claim because of their transgender status. You might have someone who doesn't. Those are the things that we let juries work out, and there's nothing unusual about that in the context of Title VII.
I think, Mr. Bursch, maybe you answered Justice Gorsuch's question now. You didn't answer mine.
Okay.
Title VII is a statute about individuals and whether individuals are being treated differently because of his or her sex. It's not a statute about, well, in the aggregate, does this act disadvantage men versus women or women versus men? It's a statute that uses the word individual twice and says, is a particular person being treated differently because of her sex? And here, Ms. Stevens was being treated differently because of her sex. And this was Judge Flom's point in that opinion, is that it's as simple as looking at the language of the statute, applying it to a particular individual, which Title VII insists that you do, and coming up with the obvious answer. Yes, if she had not been if she had not been assigned at birth the sex that she was assigned at birth, she would have been treated differently.
We agree with the individual treatment. That's why in OnCal, this court said, basically in the context of a male-only workforce, that the plaintiff had a cause of action because he was being treated differently than a woman in his position would have been. A hypothetical comparator, to get back to some of Justice Ginsburg's questions. Even if there are no women on the site, you still have that hypothetical comparator. Here it's individual too, but all the employer does in enforcing a sex-specific dress code, applied neutrally to everyone, recognizes that there's differences between men and women. And if you say that Tom Ross can't do that, then there is no...
Are you pinning your answer on the fact of a dress code? Would your answer be the same if there were no dress code and Ms. Stevens had just been fired for being transgender? Because all your arguments in your brief, I mean, you keep talking in your brief, as you do here, about the dress code, but the arguments that you make are arguments that would allow the employer to fire Ms. Stevens for being transgender, irrespective of whether there was a dress code?
Here's the reason why, Justice Kagan.
So why what? That the arguments do go that far?
Well, the arguments apply in both situations.
Yeah,
because
if there's a dress code or if there's not a dress code.
Because if this Court allows a sex-specific dress code because it acknowledges the differences between men and women, it's no different if an employer without a dress code imposes the same policy on an informal basis. It doesn't change the fact that women are not being treated worse than men. As Ms. Karlan said, it doesn't treat her worse than doesn't treat men worse than women, that we wear a tie in this courtroom and that women do not. Sex-specific policies acknowledge that there are differences. So whether the sex code or the sex-specific dress code is in place or not, employers have that latitude. Now, some jurisdictions, like the District of Columbia, have taken that latitude that Title VII gives away from employers. It says that you cannot, for example, treat someone differently based on their personal appearance. But otherwise, when it comes to dress codes, grooming codes, opposite-sex facilities, and all those types of things, everyone would have understood Title VII at the time of its enactment as those things being equal treatment and not disfavoring either sex over the other, whether on a group basis or an individual basis. It doesn't make any difference. The problem here is that under their theory, the federal agency that brought this claim and then an unelected panel in the Sixth Circuit changed the law. They added a transgender classification, applied it to a business retroactively, and what's more, the Sixth Circuit said that sex itself is a stereotype. And Mr. Cole agrees with that 100%. Everything that he said this morning, sex itself is a stereotype. You can never treat a man who identifies as a woman differently, because to do that is sex discrimination. When you do that, there is no sex discrimination standard under Title VII anymore. It's been completely blown up. One other point on the restroom scenario. Gender identity is a broad concept. You could have a male employee who identifies as a woman but doesn't dress as a woman, looks like a man, showing up in the shower and the locker room. And again, the employer wouldn't be able to do anything about that because under Mr. Cole's theory, but for the fact he was a man, he could be there. And it's stereotyping to say men cannot be in the women's bathroom.
Thank you, counsel.
So not so bad, all things considered. It was okay. It wasn't a stellar performance, but it was certainly better than the first guy. I mean, it was serviceable. It was okay. It wasn't great, but it was all right. And I do like the way he finished. You know, it was a little bit long at the end, but, you know, the justices saw the yellow light go on at some point in that and decided to let him just finish. So that's fine. It was a little long, but he did have a really good line there about, you know, the fact is that if you apply this logically, it's like you don't have to change it. If I say I'm a woman, I don't have to change anything about myself. Can I go into a women's restroom or a women's locker room? You know, because there's no such thing as what it means to be a woman or means to be a man, right? Because there's like any behavior would be discriminatory to say, well, men don't behave that way or women don't behave that way. So it's like, then you like kind of shatter the category altogether. So it's a good line because it's like, you know, there's nothing you can pin it to say it's a true category. So pretty good. So we're going to hear some more from the Solicitor General, Noel Francisco. All right. Solicitor General Noel, what do you got from the U.S. government? Tell us, Solicitor General.
General Francisco?
Mr. Chief Justice, and may it please the Court, I'd like to make three basic points aimed at basically addressing Justice Gorsuch's comment that this is a close textual case, and I would like to respectfully argue that I don't think it's that close for three reasons.
Oh, neither side ever thinks a case is close. Judges always do, don't they?
And the first, Your Honor, is the one that I was talking about earlier, that sex and gender identity.
Noel Francisco is the Solicitor General of the United States. He is he has the job that I want to have more than any other job. I'd rather have his job than be a justice of the Supreme Court because I think it's the coolest job ever. The Solicitor General is the guy who gets to argue for the U.S. Supreme Court. Like, how cool a job is that? He's fourth in line at the Justice Department. So it's Attorney General, then Deputy Attorney General, and then some other guy, and then Solicitor General. But he's the guy who gets to go to the Supreme Court and argue cases. I want that job. And incidentally, Elena Kagan had that job at one point. Now she's a Justice of the Supreme Court. So, hey, It's good for promotion opportunities sometimes too. So let's see what Noel has to say.
Like sex and sexual orientation are different traits. They're defined. They have different definitions. As my friend just said, he agrees that they're different traits. And there's a reason why when Congress wants to prohibit discrimination based on the traits of sexual orientation and gender identity, it lists them separately. It doesn't define sex as including these traits. It's because Congress has recognized there are different traits. So as long as you treat men and women with the same different trait, exactly the same regardless of their sex, you're not discriminating against them because of their sex. The second and related
I like what you said, Amber. You say, well, a true transgender. It's like, oh, man. You're going to have a fight about what does or does not qualify as a true transgender. That's right. So now we have to have gatekeeping on what does or does not qualify as a transgender, based on whether or not they've ticked certain boxes of steps or whatever. Now, I understand your point, but still, now you have a problem of going to court and saying, like, what qualifies legally what qualifies as a true transgender and what doesn't. It's like, yeah, welcome to hell of definitions. Fun times by all.
Textual issue is that the standard for determining whether or not you're discriminating against somebody because he's a man or because she's a woman is that you're treating that person differently than a similarly situated person of the opposite sex and taking an adverse employment action against them as a result. So
No, here, I don't think it's no true Scotsman. No true Scotsman is to say all Scotsmen are drunkards. And I say, well, my uncle, who's Scott, has never had a drink, or Scottish, has never had a drink in his life. And I say, well, no true Scotsman then. So you say, well, he's not really a Scotsman. So we're saying it's not quite the same thing, because we're going into a definition of what qualifies as being. You're still looking as to a definition of who does or does not qualify. So it would be accurate to say all Scotsmen are from Scotland. I mean, would that be an accurate definition, right? Or Scottish descent or something. So we still have a definitional problem. It's like, what is the definitional quality that makes a transgender person transgender? Is it when they say they're transgender? Is it when they've taken some step? If so, what steps? So it's like it's a definitional problem. So if you say, well, what is a Scotsman? I say, well, a Scotsman is anyone from Scotland. That's a perfectly sound definitional. And you say, well, my friend is whatever. And then I say, well, he is or is not because he meets the definition. So it's a legal definition, What is the legal definition for a transgender person? So that's what I'm saying. And it is a gatekeeping problem. It's like, how do you decide when someone is transgender enough to fall within the transgender category? Am I transgender? And if so, and if not, why not? Legally. And you come up with your own legal test. What do you think the test should be legally? Because a court has to say, if you were talking about transgender discrimination, if I will say I'm discriminated against because of transgender, how do you know if that's true or not? Is it based on what I say? Or is it based on something more? What more? What's the test? What's a court to do? How is a judge to judge these things? You want a judge to judge it. Well, how are they going to judge it? Based on what they say? Is that it? Is it just they claim to be and that's the end of the analysis, or is it something more? So it's a definitional problem.
Threshold question is always, are the two people that you're comparing actually similarly situated? Now, my friends on the other side assert that a transgender man is in fact similarly situated to a cisgender man, just like they assert that a gay woman is similarly situated to a straight man. But that is manifestly not true. Because with respect to the transgender issue, the difference between a transgender man and a cisgender man is that one identifies with his biological sex and the other identifies with the opposite of his biological sex. And that is a very meaningful difference that is not grounded on stereotypes. It's simply grounded on a difference between a transgender man and a cisgender man. Likewise with sexual orientation, the difference between a gay man and a straight woman is their sexual orientation, and that has nothing to do with stereotypes. It has nothing to do with whether one is better or worse than the other. It's just a different type of relationship.
A great deal of the arguments here could be cast as stereotypes, though, right? That the plaintiff in this case or that case doesn't conform to male or female stereotypes.
That is,
and as I understand your brief, you accept that argument, and that those are good claims without respect to comparators of opposite sex. And if that's the case, what's the real difference here between the two sides? I mean,
Right.
I accept there's some delta, but it seems smaller than might first appear.
Sure. And what I would say the difference is at what stage of the analysis you're doing it. The place that stereotypes come up are when you're figuring out whether two people are in fact similarly situated. An aggressive man, take Price Waterhouse, an aggressive man is similarly situated to an aggressive woman. They have the exact same trait, aggressiveness, and the only difference is that stereotypical view that women shouldn't be aggressive. But a transgender man and a cisgender man do not ever share the same trait in the first place, because one identifies with his biological sex, the other identifies with the opposite of his biological.
I don't know if it's the first time that the word cisgender has been in a Supreme Court argument, but it might be. So take note. The word cisgender has now been in a Supreme Court argument.
Biological sex, and that is simply a different trait that is not grounded in any kind of stereotype. And a gay man is not similarly situated to a straight woman for exactly the same reason.
I mean, I think one could argue just the opposite, that there is another trait in Price Waterhouse, and the trait is conformity to traditional gender roles. So your argument would suggest, no, we shouldn't look at the aggressive woman and the aggressive man. We should instead say, no, there's this other thing, which is conformity to gender roles.
Right.
We should really look at whether the employer treats the same the aggressive woman and the docile man, the docile, effeminate man. And if the employer treats the aggressive woman in the same way that the employer treats the effeminate man, they're both fired, then the employer is off the hook. Now, you yourself say that that's not right, that in fact that's double discrimination and the employer is on the hook twice. But it seems to me that the exact same analysis applies because there is this independent trait, which is just a little bit different from the independent trait here. Here, the independent trait, so-called, that you say is the transgender identity. There, the independent trait was the refusal to conform to traditional gender roles.
Right. And the reason I disagree with that analysis, Your Honor, is because I don't think that Price Waterhouse creates some kind of freestanding stereotype claim. What it prohibits is stereotypes that show that you're treating similarly situated men and women differently. So
but
in Price Waterhouse,
I thought you answered the question that Price Waterhouse would not have prevailed if it had treated men who were not sufficiently macho in the same way that they treated women who were not sufficiently feminine.
No, Your Honor. I believe we said the opposite of that in our brief. And
so that would be okay.
Yeah, we said the opposite of that in our brief.
So they could rely on this for both cases.
Yes.
They could rely on the stereotype that the woman doesn't fit. They could rely on the stereotype that the man didn't fit, although the cases have said that the object of Title VII was to get at the entire spectrum of sex stereotypes.
And so as we read Price Waterhouse, which I have no quarrel with in the slightest, if you treat an aggressive woman worse than an aggressive man, you are violating Title VII because you're treating similarly situated people differently. Applying that here, if you treat a transgender man exactly the same as you treat a transgender woman, regardless of their sex, you're likewise not discriminating against them because of their sex. And
I want to know on a totally separate argument. See, one, it's only my characterization, not anybody else's. But I do characterize one set of arguments that you've been through as trying to work with the language of the statute. All right? And on the one hand, you have, these are individuals, individuals 4 times, and on the other hand, you have, and the arguments that were made here, and on the other hand, arguments on the other side. I'm putting that to the side.
Okay.
Then there are the horribles. Okay? And we've discussed that at length. I'm putting that to the side.
Okay.
Then I say, well, there seems to be a third set in some of these briefs. That regardless of the first two, Congress, and that's what I think the dissenting judge was talking about, and Judge Posner had a good point. I'm not saying it's a winning point, which is what I want to know.
Yeah.
That Congress wouldn't have dreamt of this when it passed the statute. All right? I heard you say, I think, we're not relying on that. Is that so? The government is not relying on that.
No, we are relying on it in this sense. One, we think it fortifies our other arguments, but I know you
Of course it does.
I know you don't want me to push on that, so I'm not going to push on that. We're lying it on the sense that to the extent there is any ambiguity.
So just a practice note here where he says, I know you don't want me to push on that, so I'm not going to push on that. That's a very, very, very smart thing to do, right? So Breyer is laying out a question very carefully, and he's basically indicated in a particular way. He's like, I'm pushing a whole bunch of things aside, right? I'm pushing the horribles aside. I'm pushing a whole bunch of stuff aside because I just want to focus on one thing at this moment. And so he's saying, look, I don't want to push because you just told me you pushed everything aside. And so it's really, really smart. He's honoring the question asked. He's honoring the question asked. There's a whole bunch of ways that he could respond to this. But he's saying, I'm not going to push because of the way you frame the question. So it's very, very respectful. Good job. This is why you get the job of Solicitor General. So just noted.
Here, we think it is strongly dispelled by the history of these statutes. And I want to address that updating issue because it's a very important question. And here, by updating it in the way that my friends on the other side would have you update it, they're actually undermining the manner in which Congress has traditionally considered updating it. If you look at ENDA, which I think refers to the Employment Non-Discrimination Act, for nearly a decade now, when Congress has looked and considered expanding the scope of the liability provisions, it has acknowledged that there are religious liberty issues at stake, and it wants to be able to take those into account, too. If you look at the states, they've often come to very similar compromises where they found peace amongst otherwise groups of very different views. But if you resolve this issue judicially, you're essentially delivering, and I hate to use these types of terms, but a complete victory to one side of the fight and nothing to the other side of the fight. You're upsetting that legislative balance.
I think that is an argument in your favor. Moreover, I think this whole category is the elephant in the room. And I think
that was the third point I was going to make.
Well, all right. I think it is. But then on the other side of what you're saying is the following, which is abstract, but no more so. In the 60s, we were only 10 years away from where people who were real slaves and discriminated against obtained a degree of freedom. And these statutes were all part of a civil rights movement that was designed to include in our society people who had been truly discriminated against for the worst of reasons. Mm-hmm. And at that time, this civil rights statute, when it was passed, would have put in the category gay people, transgender people, of people who were suffering terrible discrimination. And over time, this court has moved away from that view, finding it unconstitutional. Mm-hmm. And now, doesn't that fact, which is an overwhelming fact to me, about the nature of the country under law, argue that that's a change? That's a change that both explains why they didn't put it in initially and explains why we should, other things being equal, interpret it to include gay people and transgender people now.
No, Your Honor. For a couple of reasons, I would argue against that. And again, I'm going to put the text to the one side, but though I do think that that is our strongest argument. I actually find it troubling for courts to take that approach because I actually think it deprives the people of the ability to struggle with these issues democratically. And I think it is very important when we have these kinds of big changes that we actually convince one another that this is the right thing to do.
No one ever thought that.
So it's a good argument, but it does have its problems. He's basically saying that, you know, when the court rules this, it basically takes away from the policymaking arena. And that was an argument used to some merit and unsuccessfully in the gay marriage cases as well. Basically saying that if the court says gay marriage is constitutional, really required, that takes it away from the debates and takes away from the policy debate. Now, you can make some differentiations because at that point, you know, many states had already legalized it. And so maybe it was time for the debate to be changed. But, you know, it's a fair line of argument. It does take away from, you know, reasonable debate or debate on the point, and society is still debating it. So there's some arguments, but there's some trouble with it too.
Harassment. was encompassed by discrimination on the basis of sex back in 64. It wasn't until a book was written in the middle 70s bringing that out. And now we say, of course, harassing someone, subjecting her to terms and conditions of employment she would not encounter if she were a male, that is sex discrimination, but it wasn't recognized to be such in the beginning.
And, Your Honor, I think that that is a straightforward application of Title VII's text. With respect to what I was talking about with Justice Breyer, where we were putting the text aside, I think it is important to allow the democratic processes to resolve these issues so we have a stable resolution of the issue and one that takes into account what everybody would agree are legitimate interests on all sides. In Obergefell, this Court made very clear that there were good and decent people who had different views with respect to gay marriage, and they should be respected. The legislative process is the process that allows those views to be respected, as well as the very powerful views of my friends on the other side, which also should be respected.
May I just ask, at what point does a court continue to permit invidious discrimination against groups that where we have a difference of opinion, we believe the language of the statute is clear? I think Justice Breyer was right that Title VII, the Civil Rights Act, all of our acts were born from the desire to ensure that we treated people equally and not on the basis of invidious reasons. And we can't deny that homosexuals are being fired merely for being who they are, and not because of religious reasons, not because they're performing their jobs poorly, not because they can't do whatever is required of a position, but merely because they're a suspect class to some people. They may have power in some regions, but they're still being beaten. They're still being ostracized from certain things. At what point does a court say, Congress spoke about this. The original Congress who wrote this statute told us what they meant. They used clear words. And regardless of what others may have thought over time, it's very clear that what's happening fits those words. At what point do we say we have to step in?
I guess my answer, Your Honor, would be at the point when Congress actually addresses the issue.
So it's an astoundingly good question from Sotomayor, basically saying, look, there's all this horrible stuff that's happening, and I think, well, she seems to be indicating, I imagine she does, that she thinks that the text clearly prohibits what's happening, and so, shouldn't we step in and stop it? And Solicitor General's answer is as good as any in this situation. It's a really good question. It's a tough question. He doesn't have a massive range of great options, but he's like, well, if there's this big problem, it's up to Congress to fix it. It's not the greatest answer, but it's an answer. So, I can't think of a better answer. It's like, it's basically, if there's a huge problem, Congress has to fix this. Congress gets to write the laws, and the law doesn't contemplate this, and it's not for the court to fix it. It's not the worst answer. No, I don't think it's going to win any hearts and minds, but it's reasonable. Sort of.
And the main argument that we are making and have been making from beginning to end is that Congress has not resolved this issue because sex, gender identity, sexual orientation
General, these are
different traits.
Some thoughtful responses that you've given to this set of questions. But in responding to Justice Breyer, you said, if we thought that there was a clear application of the statute. So I would just ask you, if you thought that this was a clear application of the statute, in the same way that sexual harassment was a clear application of the statute, even though nobody recognized it at the time, if you thought that this was a clear application of the statute, would we have to come out against you?
Yes, Your Honor. If the statute is unambiguously against me, you have to rule against me.
That is both the right answer and an incredibly smart answer in my view. He doesn't deflect it. He takes it head on. It's like, if it's against me, you have to rule against me. I think that's the right answer, and I think it's an incredibly smart answer. So, like, that answer alone, like, raises his esteem a couple points in my view, because it's the right answer. It's a tactically correct answer. It's like, if it's against me, you have to rule against me. It's a very strong answer to a difficult question, and I have to give him points, guys. That was a really good answer. I really, really like that. So that earned some esteem for me, big time.
I actually think that the statute is unambiguously in my favor for the reasons I was given, and the third reason, which is the one that Justice Breyer alluded to, Justice Scalia's great line about how we don't hide elephants in mouse holes. Everybody here agrees that Congress never thought that by prohibiting discrimination based on sex, they would also be prohibiting discrimination based on two very different traits, sexual orientation and gender identity. My friends would have this court essentially reach that same result indirectly.
This is a really good close.
All of the textual arguments cut in our favor straight away, but to the extent there's any doubt, there's no way to find that elephant in this mouse hole. Thank you, Your Honor.
Really, really, really strong close, too. Really strong close. He's like, yeah. It's like, we don't hide elephants in mouse holes. It's like, there's no way that Congress meant or intended this. It's like, and it's a great answer to the conservatives, too, to quote Scalia, too. It's like, yeah, the text seems to say this, but when you look into it, it's not just the letters of the text. Like, there's like different, as I've said, there's many versions of originalism, right? So there's straight textualism, like just as pure text, but originalism does allow for you to look to original meaning, original understanding. So it's not about intent or purpose, but it's the original understanding of the language. What did the language mean to the people who are writing it? What did it mean to the Congress who's passing it? You know, on the premise that Congress is the one that passes laws, right? So they passed laws. When Congress wrote this in 1964, they had a particular understanding of what this language meant in their collective minds, right? And society had a collective understanding of what this meant when it was signed by the president and became a law. And so we're looking to that collective understanding as part of originalist understanding. So it's not about intent or purpose. It's about the collective common meaning of the language. It's not how we understand the language today. It's how the language is to be understood in 1964. Because Congress passes laws, and they passed the law in 1964. In 1964, it had a meaning. And until Congress changes the law, that must be the meaning. You know, the meaning doesn't get changed until Congress passes a different law, which means that Congress could literally pass the exact same text today, and it would mean something different today than if Congress passed it in 1964. The exact same words written today might mean something different than they did in the past, because the common understanding of what those words would encompass means something different. But the meaning is frozen the moment Congress writes it, because that's Congress's power to write laws. And so when they wrote it, they had a particular conception of its framework in mind. And so that is the right way to interpret it. So it's a very originalist argument, good rebuttal. It's like, it can't be here because Congress would have never understood it to me. It's not hidden. This elephant is not hidden in this molehill, or whatever the line is, mouse hole. So it's a very nice argument, very good close. And I really liked about the statute. It's a really nice work. Excellent work. Good job. Still not as good as the woman who opened in the first case, but it's very, very solid.
Thank you, counsel. 5 minutes, Mr. Cole.
Thank you. Interpreting a statute is not...
Oh my God, is this guy going to talk some more? Okay, guys. Strap in. If you got shots, do one. Okay, guys, here we go.
Depriving the democratic process. It is doing what the court is supposed to do within the democratic process. And of course, if the democratic process disagrees with the court's interpretation of the statute, it can change it. So there's no deprivation of the democratic process here. Secondly, the purpose of Title VII, as this court defined it, was to make sex irrelevant to people's ability to succeed at work. To make sex irrelevant to people's ability to succeed at work. When Harris Holmes fired Amy Stevens because it learned about her sex assigned at birth being different from her gender identity, it did not make sex irrelevant to her ability to succeed at work. It made it determinative. And think about it this way. If Harris Holmes fired a man because he was a man, that would be sex discrimination. If it fired an employee because he was insufficiently masculine, that would clearly be sex discrimination. In this case, Harris Holmes fired Amy Stevens because he thought she is a man who is insufficiently masculine. That, too, must be sex discrimination. She's not seeking any special protection. She is seeking, and all transgender people are seeking, the same protection that everybody else gets under the law. This court 30 years ago said in Price Waterhouse, we are beyond the day when an employer could evaluate employees by insisting that they match the stereotypes associated with their group. We are certainly beyond that day today as well, and what Harris Holmes did was to insist that she match the stereotypes associated with her group. That's impermissible under this court's precedents. It's impermissible under the literal terms of the statute, and this court should rule for Amy Stevens. Thank you.
Thank you, counsel. The case is submitted.
All right, well, fortunately he stopped talking, so that's good news. So, yeah. All right. So, wow. Okay. So, I think, now the only thing that sort of counsels me against this is the company lost at the Sixth Circuit Court of Appeals. And the Supreme Court does like beating up on the Sixth Circuit, but they tend to like beating them up on habeas issues. And this isn't a habeas issue, so this is not something they would normally beat up the Sixth Circuit about, but the company lost at the level below. My best prediction for the outcome of this case is they're gonna dig it, baby. D-I-G it, baby. Dismiss as improvidently granted. They're gonna say, we should have never heard this case. We were wrong to accept this case. We don't know anything about this case. We didn't accept this case. We don't know what you're talking about. What case? What case? We've never heard of this. Go away. And so my best prediction for this is they're going to dig it. They're going to dismiss it, improvidently granted, and it's going to go away. And the decision below is just going to stand as though the Supreme Court never had this argument and there were no briefs and nothing happened. So yeah, I think they're going to dig it because, yeah. Now, that's my best guess. As to the other case, the sex improvidently cases, the sex cases, it's a little bit more interesting. It's an interesting position for the conservatives because it's an interesting line of argument for conservative legal thinking. Like for left-leaning liberal thinking, what should we call it? Progressive legal thinking, I guess would be the best term, because liberal implies something else, right? Because liberal deals with individual liberty interests strictly. So we'll call it progressive. For progressive legal thinking, it is, basically there's this long-standing discrimination's wrong, and, you fill in your own progressive argument. So the progressive argument is fairly easy. The conservative argument is interesting too, because if you're a pure textualist, the pure textualists would say that probably the discrimination is wrong. And so then you have to go beyond pure textualism and you have to go into some sort of originalism. The problem there, of course, is like when you start talking about history and you start talking about intent, you start talking about purpose, those are not classic conservative lines of thought. But you do have this saving idea. It's like, well, when we're talking about text, what we mean when we say text is what the text understood at the time it was passed or came into being. So like the First Amendment means what it meant when it was passed. The 14th Amendment means when it was passed. When Congress passes, if Congress passes a law today, if Congress passes a law right here, right now, today, Congress still passes laws, right? If they were to pass one today, then I think we can all agree that Congress has particular meanings in mind. They have particular ideas in mind. The text reflects something, but the text has a meaning that's understood by everyone who's writing it, everyone who's reading it. It has a common understanding, or at least hypothetically does. that's in everyone's mind of what this text means. It's not about purpose. It's not about intent. It's about what the language actually means. Because to give exactly a good example of this, the clause that most directly impacts me is the intellectual property clause. Article 1, Section 8, Clause 8, because as many of you know, my day job is a patent attorney. And that is Article 1, Section 8, Clause 8. And it has language in there to promote the progress of science and the useful arts. And the funny thing about that language is it's basically flipped in terms of what it means today as opposed to when it was written. When they wrote science, they don't mean what we mean by science. When they wrote science, they meant scientia, as in terms of knowledge. So when they wrote to promote science, what they meant was promoting knowledge. That's copyright. It has nothing to do with labs. It has nothing to do with like technological discovery. It has science in that frame means knowledge. It's what we would now call art. Okay, so when they say to promote science, they mean art. When they said to promote useful arts, they didn't mean art. They meant technology. Useful arts are technology. It's a phrase that means technology. It's basically a phrase that means science, okay? So when they wrote science and useful arts in 1787, when they wrote the Constitution, that language means almost exactly the opposite of what we would now mean. If you were using those terms now, you'd flip it around. But, we still use the terminology because it's what they wrote in 1787. So by the same token, when Congress is writing a law in 1964, and they say discrimination against sex, let's work on the premise that Congress passes laws, right? Congress is the one that passes laws, and that's how laws get created. So they have a collective meaning in mind, a collective understanding of what that means. And if Congress wants to change it, Congress can change it. But there's a mechanism for that. There's a mechanism in the political branch by changing things. So the argument from the conservative would be we shouldn't read past what Congress was looking to do. We should look only to their collective meaning of the text as it existed at the time. And so that's sort of the conservative argument to that. And of course, the liberals will beat them up endlessly on the textualism. And you can be well assured that when the liberals write their decision, whether it's in majority or not, whoever winds up writing this thing for the liberals, I'm going to say Kagan's going to write it because she seems like the most obvious person. I think when Kagan writes this decision, whether it's in the majority or not, it's going to be very rooted in textualism because it's just going to be like trying to basically like burn the conservatives for not being loyal to their own principles. So I think that's probably the likely outcome. But the question is, what's the correct frame? Is it discrimination on the basis man and a woman both get married? Is it discrimination because one got married to a man, or basically discrimination because they both got married to a man, and for one that's acceptable and one's not? Or is the difference that one got married to a straight partner and one got married to a homosexual partner? So the question is, what is the sameness and what's the difference? If a man gets married to a man and a woman gets married to a man, is it the same because they both got married to a man? Or is it different because one got married to a straight partner and one got married to a homosexual partner? And does that distinction matter if you're interested in sex versus sexual orientation discrimination? And does it matter when Congress is trying to pass things? So I think 5-4, they're going to say essentially that Congress didn't mean this when they wrote it at the time. I think they're going to say that the discrimination is okay because Congress, when they wrote it, didn't contemplate it. They didn't hide this. And Congress has, by all these parallel things, shown that when they want to do it, they know how to do it explicitly. Congress knows how to amend these things explicitly. And so Congress, if they want to do it, they can do it, and they can do it explicitly. So 5-4, I think that they're going to rule that a discrimination on the basis of sexual orientation is not protected by Title VII. And that would be the line of argument. So who do I think is going to write this for the majority? Probably, let's see, Alito. I think Alito's going to write for majority, and I think Kagan's going to write dissent. 5-4, I think they're going to say that discrimination on the basis of sexual orientation is distinct from discrimination on the basis of sex. And I think as to the transgender issue, they're going to dismiss it improvidently granted because they don't want a piece of that and leave it for another day. So that is my thinking on how the court will think about this and how they will apply various legal principles in terms of thinking about this. So, well, Eva Coleslaw, I'm glad that you think I'm right as to what the result will be. At least I'm showing clear thinking. That's all I can ever hope for is try to be a clear thinker about this. So, yeah. So only time will tell. We'll see. But yeah, I think they'll dismiss. They might just, what they might do. They might actually instead of digging it, they might vacate it and remand in light of their decision here. Now, I understand that one doesn't really speak on the other, but if they decide that discrimination on the basis of sexual orientation is not protected, so as for these transgender case, instead of digging it, what they might do instead is vacate and remand for further decisions in light of the decision they just rendered in the gay case. They say, we're going to vacate your decision in the Sixth Circuit. We're not reversing it. We're just going to vacate it. So we're erasing it from the books, because we can do that, because we're the Supreme Court. We're not affirming. We're not reversing. We're vacating it. And we're sending it back to you, and we're going to say, please consider it again in light of this other decision we just reached. And you figure out what we intended and see how it goes from there. So that's actually a more probable result than digging it, is actually a vacate. So vacate it in light of the decision they're going to render in the gay case. So 5-4, they say it's not protected. Vacate the other case in light of that case. Send it back to Sixth Circuit. Say, take another crack at it and see if you come up with a different answer the second time. So we don't have to decide this issue right now because we don't want a piece of this stuff. So, yeah. Because I think the Sixth Circuit will get the message and be like, yeah, we changed our mind. Not for the least the reasons that if they vacate it, it will go to a different panel. I think I'd have to look at how the Sixth Circuit rules are written, actually, about whether it gets to the same panel or not. I don't know. I'd have to read the Sixth Circuit's rules in terms of how those cases get assigned. So it might get assigned to a different panel, and different panel judges might hear the case for all I know. But yeah, I don't think they're going to decide the merits. I think they're either going to dig it or they're going to vacate it and remand it and 5-4, and they're going to issue it on a Friday at some point in the near future on a day when no one's paying attention. And we can look forward to the many speeches about how the Supreme Court is horribly discriminatory and all the rest of it. You can see the political manifestations, right, unfolding before your eyes. You know exactly what everyone's going to say, right? It's like, how 5-4 is going to decide, and then you know what the Republicans are going to say, right? And you know what the Democrats are going to say, right? You can see the talking points being written in front of your mind right now. It's like, exactly how this is going to be said and how it's going to impact the campaign, and you know what the candidates are going to say. You already know what Elizabeth Warren is going to say. I can tell you what Elizabeth Warren is going to say about this decision 4 months from now. Because it's just applying what we know about how they think and about the politics of the situation. So it's like you can write it all in your mind in advance. It's like, how the story ends. So, okay, well, assuming that, but that's what you would think. So, yeah. Okay. Anyways, there were some questions. Will I cover NYSRPA oral arguments? What is NYSRPA? Oh, the New York, the Rifle and Pistol Association case, the Second Amendment case? Yeah, probably. They're going to have those have those been scheduled yet, those oral arguments? So that case deals with whether or not you can keep a firearm outside your home, whether you can transport it outside your home. There's an issue as to whether or not the case is moot because of the amendments to the law the city of New York passed. And the Supreme Court put in a note that they want them to argue mootness and also argue the merits. But yeah, I might do a reaction video to that when that's argued. Of course, it will have to be on a Friday because regardless of when they actually argue it, they release the transcripts. They release transcripts same day, but they don't release the audio until Friday. Don't ask why. I don't invent the rules. I'm just telling you what it is. Transcript same day, audio on Fridays. Don't know why. That's what it is. But yes, we probably will cover that. If there's an impeachment trial in the Senate, will that throw off the Supreme Court schedule? I would imagine, because Chief Justice Roberts going to be busy. But, Chief Justice, probably not as much as you would think, because Chief Justice Roberts, it'll be interesting if he has to be in two places at the same time. Because, the Supreme Court only hears oral argument like once or twice a week, typically. So it may not be as big of a deal as you might have. It might very well be. I don't remember how they did it when Rehnquist was in on the bench when Clinton was being impeached. So I'd have to look it up historically how they handled it. But it might very well be that he's shuffling his time between the Supreme Court for oral arguments and the Senate for for the impeachment hearings, and it will be entertaining, I'm sure, as they figure that out. But it probably won't disrupt things as much as you might suspect, because he'll just offload more of his responsibilities on the other justices. I'm sure they'll accommodate him, so they'll be fine. Yeah, they'll cover mootness at oral arguments. Yeah, I'm sure they will. The New York State thing will be interesting on the mootness issue. And there was also that brief. Did anyone read the brief from Senator Whitehouse? It was like pretty pissy. It was almost threatening the Supreme Court. I mean, it was veiled threats, but it was almost threatening. Basically, like, if you don't decide for us, we're going to pack the court and stuff. I mean, it was kind of spicy language, especially from a sitting senator to the Supreme Court. Basically, I mean, it was professionally written, but still, like, if you read between the lines, it's like, wow, this is pretty aggressive for an amicus brief to the Supreme Court, man. It's like, geez. It's like, wow. I almost couldn't believe he was writing language that strong. It was really messed up. How much does SCOTUS sit around talking with cases with each other in chambers? I honestly don't know. Their entire process internally is secret. So they do have their scheduled day during the week. It's on the calendar. When they hear cases when they discuss cases during their conference days, it's on this calendar for their initial discussion. But how much they discuss things and in what way they discuss things before they decide, it's a big secret. And the Supreme Court is surprisingly and amazingly good at keeping secrets. It's probably because everyone knows that, like, a clerkship with the Supreme Court carries with it outstanding future career prospects. And if you got caught leaking something, it would burn you forever. I mean, it's like you're gonna. I mean, to be quite honest about it, graduating from this, is graduating the right word? Sure, why not? Graduating from a Supreme Court clerkship will get you like a $250,000 signing bonus. A $250,000 signing bonus with whatever firm you come to after that. It's a pretty big deal. So it's worth like a $250,000 on top of whatever salary you're going to be getting at whatever law firm you're going to work for. So that's a pretty big deal. So they're disinclined to screw that up, so the Supreme Court does not leak. So how they do things internally, I don't know, but they're very, very good at keeping secrets. So, yeah. All right, guys, that's all. I had a lot of fun today with this. I hope you did as much as I did. This has been 3.5 hour stream. I hope you enjoyed it. I actually really did too, and I think we learned a lot by listening to the oral arguments and hearing how they argue and how we think, and we saw some really good arguments today. And we saw some arguments that were not so good. So we saw some ways to do it, and we saw some ways to not do it. So it was a very good teaching tool for us all. So we saw some really solid stuff from the Solicitor General as well, as you would expect. He has a lot of practice before the Supreme Court. Anyways. All right, guys, I'm going to sign off for now. I love you all. Please, as always, if you haven't already, go to facebook.com/uncivillaw. That's uncivil law, one word. And like the page. I just am publishing stuff there, but it's a way to gain exposure. Please like, comment, subscribe on this page if you haven't already. Tell your friends. Hit the bell. Blah, blah, blah. You know the drill. I'm not really good with this. And and off the couch, the latest in the Blizzard issue. I'm looking forward to covering that on Sunday. Should be fun. The dumpster fire just grows and grows and grows. It should be fun for all. Until later, my friends, I'm out. Hope all is well. Cheers and goodbye.